This hearing doesn't waste any time. Before the first witness was called, the defense comes out swinging, accusing the prosecution of withholding important exculpatory evidence. The prosecution fires right back, saying the evidence was disclosed all along and that the defense simply chose not to investigate it. My first impression, it felt like less a bombshell discovery and more like a last-minute scramble to get some extra time by a lawyer who seems to want to do as little as possible. But in the end, the panel wasn't convinced because his request went nowhere and the hearing moved forward. Now, it's not a criminal trial. It's a proceeding before the Michigan Attorney Discipline Board involving an attorney who prosecutors claim is incapacitated by mental health issues. They're asking to have his law license transferred to inactive status, at least until a psychological evaluation can determine whether or not he's fit to continue practicing law. To support their request, the prosecution calls several police officers who have previously interacted with this attorney. And as they describe what they've witnessed, a picture begins to emerge of someone who just might be experiencing some paranoia or delusions or some kind of significant mental health issue. Or maybe they're completely wrong. Because if even a fraction of what the attorney believes has actually been happening to him is true, then there's a whole different tone to this case. As the hearing unfolds, you'll hear testimony that's genuinely hard to believe, along with a defense that, in my opinion, struggles to gain any traction. In fact, after watching objection after objection get overruled, and watching this defense attorney attempt to keep his composure, I started wondering if maybe he was going to need a stress ball or a vacation. But whatever the truth ultimately is, this is one of the most unusual attorney discipline hearings I've watched in a long time. So let's dive right in and see what happens.
This is a hearing of Tri-County Hearing Panel number 103 of the Attorney Discipline Board of Michigan in the case titled In the Matter of Joseph A. Campbell II. The panel is composed of myself, Timothy Guerrero, chairperson, Brian J. Cole, member, and James C. Thomas, member. This panel has been appointed by the Attorney Discipline Board, the adjudicative arm of the Michigan Supreme Court, for the discharge of its constitutional responsibility to supervise and discipline Michigan attorneys. Counsel for the grievance administrator is Caitlin Fleming, who will present the case for the Attorney Grievance Commission, a separate branch of the Michigan Supreme Court for the investigation and prosecution of discipline matters. Respondent is represented by Gary Sandfield. This hearing will be conducted according to Michigan Court Rule 9.121 sub B, the rules for circuit court bench trials and the Michigan Rules of Evidence. Under Michigan Court Rule 9.121B, it is the duty of this hearing panel to determine whether a respondent is, quote, incapacitated to continue the practice of law because of mental or physical infirmity or disability, or because of addiction to drugs or intoxicants, close quote, as alleged in the grievance administrator's petition to transfer to inactive status. The allegations of misconduct set forth in count 2 of the formal complaint that is combined with the petition have been held in abeyance pending this panel's decision regarding respondent's alleged incapacitation. In the petition to transfer to inactive status, the administrator requests that the panel order respondent to submit to a psychological examination by a licensed psychologist and a substance abuse assessment by a therapist who holds a certificate as a certified advanced alcohol and drug counselor. At this hearing, the panel will determine whether good cause exists as required by NCR 9.121B sub 1 to grant the administrator's request. We will now proceed with the hearing. The panel would inquire of counsel at this point whether there are any preliminary matters that need to be addressed before we begin presentation of the grievance administrator's case in chief.
I have a preliminary matter which I discussed with Ms. Fleming off the record, which I think we should put on the record. I'd like to make this motion now. Preliminary matter. May I proceed?
All right. Are you saying that Ms. Fleming and you have agreed?
No.
To put this motion on the record?
Well, I discussed it with her and asked her, do you want me to put it on the record? And she said yes, and I think it's important too. And
All right, well then you can proceed.
okay. Um, this case to a large degree, I received a witness list, exhibits, and police reports from Miss Fleming on August 6th, which would have been Wednesday of last week. And on her witness list, she has 4 police officers identified. And in reviewing their reports, it appears that she's trying to use those reports to establish somehow that my client doesn't have the mental capacity based on what took place during those police runs. However, what she didn't do is there was an additional police report which she provided, which is not listed on her witness list and who she doesn't intend to call, which is of an exculpatory nature. And I could give you an offer of proof if you want it, but it's an exculpatory nature. And because of that, I think we have a constitutional issue here, a violation, because Brady versus Maryland, 373 U.S. 83, 1963, it requires the disclosure of it mandated that all material exculpatory evidence be supplied to the defense. There's a similar court rule too regarding MRPC 3.8D, or Michigan Rules of Professional Conduct, requires the prosecution to disclose to the defense all evidence or information known to the prosecution that tends to negate the guilt of the accused or mitigate the offense. So you've got the professional rules of responsibility, and you've got the Brady versus Maryland case. And it's very clear that, and then the Brady versus Maryland case goes on to the Giglio versus United States, and that basically states that the rules requiring providing exculpatory evidence to the opposing side are designed to ensure fairness and integrity by promoting transparency and disclosure of all relevant information. So also a violation would occur. So there's a Giglio violation and there's a violation of the Brady versus Maryland, because one of the police reports I received, I didn't get it until August 6th. That would have been 2 days before the hearing, essentially, and wasn't in a position to subpoena that police officer as one of the officers who did respond to my client's law office in response to his calls of a potential breaking and entering. And by way of offer of proof, she has 4 police officers who are going to testify that they responded to the office on an allegation of a B&E and didn't necessarily find evidence of a breaking and entering into the office. Yet the police officer she didn't list, until I didn't learn until next week, was like an investigator, and he came in and dusted for prints, and his report is clear. It says that he finds that there was a breaking and entering, and he describes which door it came through and what proof there was of a breaking and entering. So that would be potentially exculpatory evidence when you consider she's got 4 police officers she wants to use to try to state my client doesn't have the mental capacity because of things he did during those reports and because of calling the police in the first place. But then I find out 2 days before the hearing that there's an exculpatory report also of an officer, his name is Swenson, who she didn't endorse or doesn't plan to call. So those are violations that puts us at a clear disadvantage. Now, the general rule for failure to follow the Brady rule and the Giglio rule is that upon a conviction, it would be set aside. But rather than going through this whole hearing, and if you found my client incapacitated and then bring this up at the end, I thought since I know about it up front, I don't think that would be the way to go. So I want you to consider how we should handle that. Should it be an adjournment? Should something else take place in view of that violation?
Well, first of all, Ms. Fleming, do you have a response?
Yes, thank you. Caitlin Fleming. Can you hear me all right?
Yes.
Thank you. Caitlin Fleming on behalf of the Agreements Administrator. This petition was filed on April 8th, 2025, It was also emailed to Respondents Counsel on April 11th, 2025. And that was done because he represented Mr. Campbell during the investigation. On June 2nd, 2025, Respondents Counsel was notified of individuals who may have information about the matter and the allegations, and that letter was sent by email again on June 2nd. Additionally, he was copied on proofs of service relative to our filing of subpoenas in this matter on July 22nd, 2025. I emailed Mr. Sandfield I emailed him anticipated individuals that I believe would be identified on the witness list on August 1st, 2025. Those emails also included what I anticipated would be proposed exhibits and included the law enforcement reports as well as the fire department reports that I anticipated witnesses may rely upon or may be reviewing during their testimony. And then on August 4th, 2025, the witness and exhibit list was filed. I'll also point out that Mr. Sandfield had an opportunity but did not file a demand in this case. And so the information was provided ahead of the witness and exhibit list. And with respect to the individuals that I anticipate will be testifying today, the detective that oversaw the breaking and entering investigation is expected to testify today regarding those allegations. Nothing prevented Mr. Sandfield from doing his own investigation, from subpoenaing the individuals that were identified and provided to him back in June. That's the record for today. I'm happy to answer any questions if the panel has any for me.
Briefly, in response to the statement that she supplied a list to my office, she supplied a list of names only, and there was probably 50 of them on that list. And it didn't state who she planned to call and what these witnesses were for, all it has with names. There was probably 50 of them. So I had no clue as to who she planned to call or what the purpose of them was. Not until August 6th, when I received her witness list and the exhibits that she sent me on August 6th, did I realize that a key exculpatory witness was not on the witness list and was not going to be called. And I reviewed all the police reports and realizing that was there, and it was only 2 days before the hearing, I couldn't react to that. And counsel's request that I didn't make a demand, the Brady rule is clear. Brady versus Maryland, because I knew this was going to come up, and I explored this in detail, and Brady makes it clear that the prosecution, strike that, the prosecution's obligation to provide potential exculpatory witness information does not need to be requested or demanded by the defense counsel, but rather it has to be provided whether it's requested or not. And the case is listed, as I stated, 373 U.S. 83, 1963, and it is contained in that case. It's also contained in the Giglio case. There's no requirement that the prosecution demand all potential exculpatory evidence, but rather the burden is on the prosecution to prove and to supply the defendant with all potential exculpatory information. And I don't think there's any disagreement that for purposes of this hearing, the Attorney Grievance Commission is considered the prosecutor, and she admits that even in her initial pleadings, where it says in her initial pleadings, I think it's on number one, formal complaint by Attorney Grievance Commission, which is the prosecution arm of the Supreme Court, for the discharge of its constitutional responsibility to supervise and discipline Michigan attorneys. So she can't say she's not a prosecutor. For the purpose of these proceedings, she is a prosecutor. And it's not fair to myself or to my client to have to move forward with this clear violation, especially when the allegations of incapacity, some of them are 17 months old. There's nothing current to show that my client, his current status. I requested an adjournment for that purpose, but it was denied because there was something pending, but it hasn't been completed. But notwithstanding that, this Brady violation is a problem and I'd ask you to handle it in a manner you think is appropriate, but I don't think it's fair. I think my client's been prejudiced by our inability to call an exculpatory witness at the last minute.
Anything further, Ms. Fleming?
Are you talking to me, sir?
No. Ms. Fleming, do you have anything further?
No, other than the grievance administrator is prepared to proceed today. There has not been a violation. What he's complaining of with respect to only providing the names, the addresses were also provided, and that's pursuant to the discovery rules under MCR 9.115 that was provided. Again, there are proofs of services that have been filed indicating when he was provided the filings. As a courtesy, I provided the information ahead of those dates and those filings. There has not been a violation. We're ready to proceed.
Mr. Sandfield, just so the panel is clear here, you say that you have a copy of this allegedly exculpatory police report. You've seen this report?
Yeah, she supplied it to me with the I received it on August 6th when she supplied all the police reports and a witness list, an exhibit list on August 6th. This is the first time I saw that report, and that report, I have a copy of that report because she provided it to me. And you want me to summarize what it says?
No, you don't need to summarize it, but you are certainly entitled during the course of this hearing to offer and enter that report into evidence, are you not?
I am, but not on 2 days' notice.
Why not?
Because how do I subpoena and get an officer to appear, a police officer?
No, I'm not talking about the officer. I'm talking about the report.
The report would be hearsay unless she wants to stipulate to it. It's a police officer's report. That's hearsay. If, you know,
I'm sure Ms. Fleming would be happy to stipulate to the admissibility of that report as an official record. Would you not, Ms. Fleming?
If he can indicate the police report number that we're referencing, I would not have an issue. I would just want to ensure that it's the complete report that is being provided.
That's fine. My question is this: if Mr. Sandfield is able to offer and establish that police report as an official record, and you stipulate to its admission for the panel to give whatever weight or consideration it deems appropriate, does that address the issue here?
It's not, I'll defer to Mr. Sandfield as to whether it addresses the issue. I don't believe there is an issue here relative to it.
Mr. Sandfield, does that satisfy the concerns you have?
it really does not, sir, because it's not really fair to my client, because I would have liked to talk to the police officer also and interview him in advance to, get him to see if I can expound on his report. And I'm sure that's what counsel is going to do with her, the police officer she called. So my inability to call this police officer, I still think prejudice us, just because she's willing to stipulate to the report, doesn't undo the damage pursuant to the cases I've cited.
So you received this report last Wednesday, August 6th, identifying the officer and the contents of the report. Did you take any action on August 6th, 7th, or 8th to deal with it?
No, because I didn't think it would be feasible to expect the police officer to, first of all, I would need to talk to the police officer in advance as to what his testimony might be, and then he would have to be up here today. I didn't think that was feasible. No, I didn't think that it was my obligation to have to be scrambling with 2 days' notice on exculpatory evidence that should have been provided months ago. Why is the burden on me to respond why do I have the burden to respond to and take steps on exculpatory evidence 2 days before a hearing when counsel's had this for since 2024.
Well, the question is whether or not the allegedly exculpatory evidence is going to be put into evidence for this panel to consider. And
If I would have had notice, appropriate notice, I would have definitely called this witness after I talked to him and confirmed that what he says in his report is accurate and that's what he intended to testify to. And I would definitely call him because it's clearly exculpatory. It clearly shows that he clearly states that he found that there was a breaking and entering into my client's office building, and counsel's 4 police reports say that there wasn't.
all right.
Can I jump in?
Yeah, I was going to. Does any of the panel have any other question?
Is there a discrepancy as to when this was emailed out, Ms. Fleming?
Yes. The timeline that Mr. Stanfield indicated, from my perspective, is inaccurate.
You're saying the 3rd, and he's saying he didn't get it till the 6th?
I emailed it to him on August 1st, 2025. That's when the initial emails of the individuals I anticipated would be on the witness list. The exhibits I anticipated would be submitted in my witness list, as well as all of the reports from law enforcement and the fire department.
How long?
That is subsequent to the letter that was provided in June with all of the individuals that may have information relative to the proceedings today.
You think that 50 witnesses and addresses on a witness list is a little bit of hiding in the woods without identifying what it is that they say?
What I would indicate is that under MCR 9.115, under F4A2, it indicates that following an answer that the parties will exchange names and addresses of all persons having knowledge of the relevant facts. As indicated in the petition, there are numerous courtrooms, court hearings that these allegations stem from, and there are numerous incidents and law enforcement instances where law enforcement was called to respondent's place of business. That's what was provided, what was outlined in the discovery procedures.
The actual report that we're talking about, when did you get that report?
Are you talking to me, sir?
No,
I would have to go back and look in terms of the investigation, in terms of when that report was received.
Would it be fair to say that it wasn't turned over as soon as you got it?
That would be fair to say. Our files are confidential, and generally the reports as they are received during an investigation would not be turned over.
But not confidential as it relates to the respondent or his lawyer. He would be entitled to a Brady disclosure, wouldn't you agree?
He would be. It was never requested relative to the investigation that I can recall off the top of my head. And my read of the police reports is that the final conclusion is not what Mr. Stanfield is indicating, but relative to that, he was provided the reports.
So whether you disagree or not, you understand that I think what the issue here is going to be timeliness of a Brady disclosure. Agreed? Well, you disagree that it's a Brady disclosure. He's arguing timeliness. So then let's talk about the number of witnesses that you have and for today's hearing and whether you expect to finish today with cross-examination.
So for purposes of the hearing today, I have subpoenaed 3 law enforcement officers and a fire department lieutenant, as well as an attorney. And I would anticipate calling respondent as well. I'm not sure that we will get through everything today.
So we would not even get to Mr. Sandfield's case where he presents his evidence until the adjourned hearing.
That is a fair assessment.
And if we did have the hearing a couple weeks or months off, depending on schedules, and we had some difficulty scheduling, he wouldn't be prejudiced by the lack of timely disclosure if he had the chance to meet, talk, and call the witness if he chose to.
I take the position that it was not an untimely disclosure, but I do not believe that he's been prejudiced or would be prejudiced if he had additional time subsequent to today's proceedings to pursue the individuals whose name he had since at least June.
Okay. Well, I don't have any further questions. Do you have any further questions? Anybody else?
Mr. Cole? No?
No, are we going to be discussing this today?
We're going to go into a breakout and have a panel discussion on this motion, yes.
By the way,
great.
sir, as far as the dates, if there's a question, I'm looking at the letter from.
I was asking panel members.
Okay. No, but I just said, do you want me to point out, you want me to confirm the date I received this? Because I have I saved the envelope with the postmark on it and the letter from their office.
But there's an email. When was the email sent?
It wasn't emailed, it was mailed by first class mail. I received it on, the envelope is postmarked the August 5th, even though the letter is dated August 4th, and I received it in my office on August 6th. And I did save the letter from the Grievance Commission because it came by first class mail. It didn't come by email.
Ms. Fleming, do you want to offer an exhibit?
I can offer an exhibit relative to, I did not anticipate this issue, but I can certainly provide the emails. I think the proofs of service relative to the witness and exhibit list are already on file, but I can certainly provide the letter that was sent to Mr. Sandfield with the individuals' names on June 2nd, as well as the emails that occurred on August 1st. If the panel would like to see those, I can certainly provide those.
And Mr. Sandfield, you're still sticking to the story? You didn't receive an email?
An email on what? I did receive an email with a list of like 50 people.
I'm talking about the August 1st email.
What was the August 1st one? I didn't understand. What were you saying was August 1st?
She's saying that she emailed the information that you received on August 5th or 6th on August the 1st.
That I am not certain of. I don't, if I did, I don't have that. I can tell you that. What I have is what was mailed.
All right.
I don't think that was.
I have no further questions.
I just want to say one thing, Mr. Thomas, that I don't want to bifurcate this. She has 4 witnesses. I don't know how long that would take, but I don't want her to go to this through the end of the day because I don't know how long it's going to take and then say, I can come back with my witness. I don't think that's in the interest of justice. Also, another reason to continue this is because I have a pending psychological evaluation from a psychologist in Birmingham who neither myself nor counsel picked, who's a neutral psychologist who my client went to, but that report won't be available until September. So that would be another basis, and that could serve as a basis to settle the issues and not even have a hearing.
So just so that we're clear, and I don't mean to interject, Tim, but so that we're clear, you suggest it's not in the interest of justice to bifurcate the matter, but you need testimony from a psychologist who's going to be evaluating him in September?
No, he's already evaluated him. We're just waiting for his report. The report.
But it's not going to be due until September?
Right. It might be late September. Go ahead.
And you would intend on introducing his report once you've reviewed it?
I don't know. I have to review it and then make a determination. But
But if we don't bifurcate it and we don't have the psychological report, are you planning then on resting at the end of today?
no.
Okay, so
But,
then,
I mean, man, I don't know. I can't make that determination because you might not allow me. You might not allow me to continue. I don't know what the policy of the panel is, but I don't want to be placed in a trick bag because counsel didn't follow the rules, and you're trying to cure that mistake. I don't want that mistake cured to my disadvantage. I want it to be done appropriately in the first place. And the bottom line,
That's not what no, that's not what Jim has proposed, Gary. That's not what Mr. Thomas is proposing in terms of his cures, exploring the cure situation. We're just trying to find a way of evaluating this properly and at least getting to the bottom of what is this disparity between Ms. Fleming's recollection of emailing this to you back on August 1st and now with you claiming that you didn't receive it until the 6th through the regular first-class mail. So it seems to me that would resolve a lot of this just straight away, if we can. If we can confirm that would really streamline a lot of our thought process, I think, on this. I don't want to speak for Jim or Tim, but that would seem to me to be the most streamlined resolution.
can we go into session?
Yes, and Ms. Fleming, while we are in session, if you have a proof of service relating to the August 1st email, would you please locate it and make it available to us, please? Owen, can you bring the panel into breakout, please?
Absolutely. I'll open the, actually, bear with me just one moment. I need to do one technical thing. My apologies for not seeing this first. Okay. Hi, everyone. Thanks for your patience. The panel is ready to rule, so they're going to be here momentarily.
Madam Court Reporter,
Yes,
how are you?
I'm very good. Thank you for asking. For a Monday morning.
All right, we're just waiting for Mr. Guerrero to turn on his video and his microphone, and then once that's done, he can start the record. All right.
We are back on the record. The panel has considered the motion made by counsel for respondent. We are going to proceed with the hearing today. In recognition of the issue raised by Mr. Sandfield, we will preserve his right to take whatever action he deems appropriate with regard to this potential witness. And if at the conclusion of the hearing today, we have finished with all of the proceedings that are available to us today, we will continue the hearing at a future date. Mr. Sandfield will have the opportunity to determine whether he wants to call that witness. If we finish up with all aspects of the case today, we will reconvene for that purpose if deemed necessary by respondent's counsel. In the interim, the reporting question, if offered as evidence today, will be admitted by the panel as a placeholder, if you will, for this issue.
You're talking about the police officer's report that I went to.
Report that you are referencing as being exculpatory, yes.
And what about the report from the psychologist that's going to be received in September? Is that something I could address at the reconvened hearing?
You know, that's all new information to this panel. That is not something we're addressing at this point. That's something you can take up with Ms. Fleming. If that's that's the purpose of this hearing, to determine whether a psychologist report should be undertaken. If there's one in progress and Ms. Fleming agrees that it is one she can stipulate to as appropriate, then why are we here? But
Okay,
if not, for whatever reason, then we have to continue.
Let me just explain something to you also. Myself and Ms. Fleming agreed to adjourn this hearing for the purpose of wait. Let me finish, counsel. For the purpose of obtaining that report because we thought that was a neutral report. Neither of us suggested that psychologist. And he's pretty well known. He's in Birmingham. He paid like $5,300 for the report. So I have a feeling he's not a hack. But I don't know him at all. But I'm just basing my analysis on his pricing. But in any event, we agreed to postpone the hearing, and when the stipulation came in from counsel, she had terms and conditions in it that I couldn't live with, and that's why the stipulation never moved forward. I was a little surprised that when I made the motion to adjourn, a first adjournment, that was denied, because that was my main reason. I'm not trying to, and also this wasn't a date I selected. One of the dates I selected was August 15th. They crammed this date down my throat of August 11th. Not that it would have made a lot of difference, but that report.
Haven't we already ruled on this, Mr. Sanford?
Yeah, we're not making any issues on this report. If you were unable to stipulate with counsel on the report, then we're moving on to the question in this case is whether psychiatric examination should be ordered. So with that, if there are no other issues, Ms. Fleming, it's time to start presenting your case in chief.
Thank you. Did the panel still wish me to submit the email that was referenced? Yes. Okay.
Yes, please.
I'm happy to do that.
You don't have to do it right now, but let's move forward.
May I make a brief opening remark?
Yes.
Thank you. On April 8th, 2025, the grievance administrator filed a petition as to Mr. Campbell, which includes allegations to transfer him to inactive status pursuant to MCR 9.121B. Respondent filed an answer to those allegations, and in that answer, he admits that he was placed into protective custody by law enforcement and hospitalized at McLaren Hospital. He also admits that his parents signed affidavits in his custody matter to support supervised visitation between him and his child. Those affidavits also, he admits, raise concerns about his change in behavior. He also admits to the court and to the Attorney Grievance Commission that he submitted that he was struck by lightning. Under MCR 9.121B1, this panel is required to take action necessary to determine whether an attorney is incapacitated. Today, petitioner is prepared to present testimony and documents to support the allegations of incapacity. Testimony will be presented from law enforcement, fire department representative, as well as an individual from the legal profession. At the conclusion of the hearing, petitioner will request that the panel take necessary action to protect the public, courts, and profession. Thank you.
All right. Thank you. You may proceed.
I did submit exhibits, many of which are certified records. Those are exhibits 3 through 5 and 8 through 13. Those are all, again, certified. I would ask that those be admitted for the record at this time.
3 through 5 and 8 through 13, is that what you said?
That's correct.
I'm sorry, I didn't understand that. What was that, counsel?
Exhibits 3 through 5 and 8 through 13 are all certified records. I'm asking that those be admitted at this time.
Our position, may I respond?
Yes, you may.
While they are certified and they may fall within the public records exception of the hearsay rule, I think standing alone without some foundation of some sort, they should not be admitted just by virtue of, here they are, take a look at these. I don't think that's how the hearsay rule was intended. I think there should be some sort of a small foundation before we just admit records, whether they're certified or otherwise.
Ms. Fleming?
I guess I'm not clear in terms of the objection, whether it's an authenticity or a relevancy objection. that are all certified. They've been authenticated through certification. Relative to the proceedings, they're directly related. Certified records 3 through 5 are motions that respondent filed in 3 different courtrooms. He admitted to filing those records, but he neither admitted or denied the substance of those records in his answer.
The exhibits are admitted. And we'll proceed. You can debate the relevancy through the course of
they're not really relevant without.
We're not going to argue relevancy at this point, counsel. The exhibits are admitted. You may proceed, Ms. Flynn.
Thank you. I'd like to call Detective J. Anderson first.
I will admit Detective J. Anderson right now.
Yeah, the audio connection doesn't seem to be very robust. Owen, I don't know if there's something we can do. Detective Anderson's connection here.
Sure. Bear with me a second. I'm going to Detective, do you have a different device perhaps that, or maybe headphones that would, that have microphones attached to or incorporated into them?
I do not.
Okay. I'm not entirely sure whether it's a proximity to the microphone issue and that perhaps is why the audio is cutting out, or if it's an internet connection issue. I guess my recommendation is to, I know this is going to be a little awkward, but to scoot a little closer to your device, and then try to keep the voice level up. And if that doesn't work, then we'll have to reevaluate.
All right, let's try it again.
I'm not sure if the court reporter had the entire address. Could you try that one more time, Detective Anderson?
Yeah, 3798
Who is your employer at that address?
Clinton Township Police Department.
And what is your current position?
Detective.
How long have you held that position?
I've been a police officer for 23 years and been a detective since 2007.
I didn't catch that year.
27.
Still didn't hear it. Did you?
No. This is Owen Montgomery, the case manager again. Sorry, Detective. There is a way for you to exit the meeting, come back in, and instead of connecting via the audio of your device, you can call in. At least you can do that normally when you're using a laptop or a desktop PC. I'm not 100% confident that you're capable of doing that from a mobile device, but that is an option and might clean up the audio component.
Okay, so what do you want me to do? Log off and log back in and try and call?
Actually, I don't know what you just did, but your audio is crystal clear at this point.
All right, maybe I just have to hold it like this. Does this help?
That helps significantly. So
Okay,
let's try moving
try it
forward
like
with
this.
that. Okay.
How long have you held your position as detective?
Since 2017.
What are your current duties and responsibilities as detective?
I'm a detective following up on cases, and I'm also assigned to the FBI Violent Crimes Task Force.
Were you assigned a case involving Joseph Campbell?
Yes.
Approximately when were you assigned that case?
In June of 2024, June 23rd.
And when you were assigned, what did you do?
I attempted to follow up with Mr. Campbell.
Let me back up. Was there an officer who was assigned or who was the investigating officer prior to you being identified as the detective on the case?
Yes.
And who was that individual?
I don't know. I'm not sure which officer it was.
Okay. At some point, did you have an opportunity to meet with Mr. Campbell?
I did.
And approximately when did that meeting take place?
Just over a month after I was assigned the case.
what occurred between the month that you were assigned and the point in time that you were able to meet with Mr. Campbell?
I'm going to object to that question. It's overbroad.
Overruled. Please proceed.
I made several attempts to contact Mr. Campbell by telephone. I left him several voicemail messages. He did try and call me back several times, but I kept giving him my cell phone number, and he would never call that. So he was leaving voicemails at the Clinton Township Police Department that I didn't have access to. He just finally, after a month, I was able to get a hold of him through his mom, I believe.
And you indicated that you were eventually able to meet with him. Approximately when did that meeting take place with Mr. Campbell?
August 27th, 2024.
And where did the meeting take place?
At the business where the reported crime was.
And were you able to enter the building at that meeting?
I was. I met Mr. Campbell at the business.
How would you describe the office, the inside of the building?
It was in disarray. When I walked into his office area where his desk was, there were chairs that were flipped over upside down. It just did not appear to be an office that could be utilized.
I'm going to object to that conclusion. He's not an expert in anything other than a detective, and for him to state that it's not an office that could be utilized, that's not within his purview.
Overruled. You can proceed.
What did Mr. Campbell report to support that there had been a break-in at his office?
He told me that he had been looking for evidence in his office of the break-in, and he told me several different things that he believed were evidence that the place had been broken into.
And what was the first thing he indicated was evidence of a break-in?
The chairs that were upside down, he showed me underneath the chairs there were small like screw holes, and he said that this was indication that his place had been broken into, which they were obviously just screw holes that where the chair was put together. He told me that the pattern on the chairs had been changed, like they had been reupholstered. He told me that there was a piece of paper that had blood on it, which it obviously didn't. And then he told me that underneath one of the desks, there was blood all over underneath it. And when I looked underneath there was no sign of any blood. He told me that one of the doors had been messed with. Above the door, he said there was holes. And when I looked at it, it was obviously just a spot where, like above a door, where like an arm would be to help the door to function better. It appeared that there were old holes from like a previous arm there, like small like drill holes.
Did you see any signs of forced entry?
I did not.
Did you ever directly ask Mr. Campbell if he had mental health issues?
I did.
And what was his response?
He told me he'd recently been struck by lightning.
After your meeting with Mr. Campbell, did your investigation conclude?
It did.
And how did it conclude?
I found that there was no evidence of a crime, and I closed the case.
And upon what was that decision based upon?
Speaking to the responding officers, reviewing police reports, watching body camera, visiting the scene of the crime, and speaking to the victim.
After your investigation concluded, did you ever contact the Attorney Grievance Commission?
I did.
Why did you do that?
I was concerned because Mr. Campbell told me he was still practicing law, and I was concerned of possible mental issues.
I may just have one moment. Detective Anderson, are you familiar with an officer whose last name is Swenson?
Yes.
Are you familiar with, did he have any involvement in your, in this matter with Mr. Campbell?
She did. I believe she was the evidence technician that may have taken photographs at the scene.
And would Officer Swenson had, as an evidence technician, made any determination as to whether or not there was a breaking and entering?
I'm going to object to count that question. This officer can only testify as to his personal knowledge.
Can you rephrase that question, Ms. Fleming?
Officer, I can try. Officer Swenson, you indicated, was an evidence technician, correct? On this case, what does an evidence technician do for the Clinton Township Police Department?
They respond to scenes of crimes and determine if they need to attempt to collect evidence or document any crimes.
If there had been any conclusion reached after evidence had been collected, would you have been assigned to the case?
I'm going to renew my objection. It's also irrelevant and it calls for a supposition.
Okay. We can proceed with the question.
The structure is that the responding officers go to a scene. If they request an evidence technician to document anything, they will do so. They write reports. Those reports are then forwarded to their bosses, their road bosses, and those road bosses approve them. Every morning, the detective bureau bosses then review all of the previous night's police reports, and those detective bosses are the ones who determine if cases are assigned to detectives.
And then in terms of what are potential, dispositions after detectives are assigned?
You could close a case with lack of leads. You could close a case as not a crime. You could develop suspects and prosecute.
And how did this matter with Mr. Campbell? How was it? What was the disposition of this investigation?
I closed it with a lack of leads.
I don't have any further questions. Thank you.
Sir, you closed with a lack of leads. That was in October of 2024, correct? Strike that, August of 2024.
Yes, it would have been shortly after my visit with Mr. Campbell, August 27th.
And you were aware that in June of 2024, that the evidence technician that counsel's referring to made a finding of a breaking and entering. You were aware of that?
Yes, that's how the report was titled.
And you were aware that in her report, she stated that the main door facing had pry marks, the door placed in the door itself. Entry had been gained through the west side door. I observed a latent fingerprint on the interior door handles. The print appeared to be partial and was interrupted. The south side door was also observed to have pry marks on the door. However, it appeared that no entry had been gained through the side door, but rather had been gained through the other door. Do you agree with that?
I understand that what you said. Yes, I did read that report.
So you read her the report where she felt that there was evidence of a breaking and entering.
Correct.
Okay. But somehow you decided, strike that. You're not an evidence technician, correct?
Previously I was, yes, but I am not now.
The purpose of an evidence technician is to aid the officer in charge or the detective in charge as to whether or not a crime occurred and how they should proceed, correct?
Correct.
And notwithstanding the fact that this detective found evidence of a breaking and entering, you made a unilateral decision to close the file.
I did.
Why was that?
I did not believe that there was a crime that had been committed.
So you were kind of like overruled the evidence technician.
Correct.
And Do you have any specialized training in mental health issues?
I do not.
Okay, you're not a mental health expert of any sort, are you?
I am not.
And anything you just testified to today, where your basis you called the Attorney Grievance Commission indicating you thought there might have been an issue there, that's just that's not based on any specialized training or expertise, is it?
Correct.
Thank you, nothing else.
Any redirect, Ms. Fleming?
Is there a way, Mr. Montgomery, to share my screen?
Yes, that is available to you.
Okay. And I recognize that Detective Anderson, do you recognize the document that's, I'm hoping, up on the screen?
Yes.
And what is this document?
The Clinton Township Police Report.
And is this related to the matter that you just testified to?
It appears so. It's hard to read. I don't have my glasses on. It's a little blurry. But that appears to be the report that I saved and would have provided to you.
And you provided the supplemental narrative to this report, correct?
I did.
And it appears, based upon what I'm hoping scanned, does this appear to be a true and correct copy of the police report regarding
Yes.
this incident?
Yes.
I would ask that the panel admit this report. It was not identified as an exhibit, but we've had significant discussion regarding its content and the other officer who was involved, that for completeness of the record, I would ask that we admit this report.
Mr. Sanfield?
We would object to that. It was not listed as an exhibit, and moreover, police reports are generally considered hearsay, and even though he testified to some of the contents, I would have to review line by line and then end up cross-examining on every line of a report. The only thing that's really relevant is that what he testifies to. We can use the report to refresh his recollection if that's necessary, but the report is not an admissible document, especially when there's a lot of stuff in there that wasn't discussed on the record.
Are you saying this was not on your exhibit list, Ms. Fleming? You're the one you filed?
That's correct. It was not on my exhibit list. I did not anticipate that we would be getting into such discussion regarding an individual that Mr. Sanfield has purported has exculpatory evidence. I think the panel should be able to read it for itself and make that determination.
Well, just so I'm clear, this exhibit is this the exhibit, Mr. Sanfield, that you are, this is the report by the individual Swenson that you were concerned about?
No, this is not the Swenson report. This is his own report that's dated in August. The Swenson report was June.
All right.
If I may respond, and that was why I had asked when you had inquired earlier about stipulating to the exhibit, I had asked whether it would be the entirety of the report, because the entirety of the report includes the detective's report. Mr. Swenson clearly is, and I can certainly put it back on, included in the report regarding this incident.
All right. This is Detective Anderson's report. Is that correct?
That's the full report with mine attached.
With your appendix attached. All right. We'll admit the exhibit subject to any argument about relevance or other issue.
By the way, you're admitting this exhibit notwithstanding the fact that it wasn't on the exhibit list?
Yes.
I'm going to keep my thoughts to myself, but if this hearing continues along these lines, I'm going to ask for an off-the-record discussion.
That's fine, Mr. Sanfield.
Thank you.
Any other questions, Ms. Fleming?
Not for this witness, thank you.
Detective Anderson, thank you very much. You are excused.
Thank you, sir.
I would next like to call Lieutenant Elliott. Who is your employer at that address?
The Charter Township of Clinton.
Approximately how long have you worked at the fire department?
Approximately 20 years.
And what is your current position there?
Lieutenant.
What are your current duties and responsibilities as lieutenant?
I'm in charge of an apparatus that I'm assigned to on a regular basis. In my case, it is an engine. I'm in charge of 2 other firefighters underneath me, responding to pretty much any call for service that you could imagine, for medicals, fires, vehicle extrications, and well above that, and maintaining control of the scene, obtaining information, and mitigating all the situations that we come across.
And were you on duty with the fire department on the evening of March 1st, 2024?
I'm going to object to this testimony. This is irrelevant. This is 17 months ago, and something from 17 months ago is certainly not relevant with regard to an allegation of current incapacity to practice law. It's my understanding this incapacity issue, and I may be wrong, but it's my understanding this incapacity issue is he has to currently be incapacitated. This is not like the second part of the proceedings where it could be retroactive and could be punitive for violation of the code, but rather this is more of a current situation whereby my client presently has the lack of capacity to practice law. Something 17 months ago is clearly not relevant as to that issue today. And since this is not a punitive proceeding, we're going retroactive to something you did 17 months ago and hold him responsible today. That's not my understanding of how the incapacity works. I read up on that a little bit. It seems to me it has to be based on his current condition, not something from 17 months ago.
Your objection is noted, Mr. Sandfield, and that certainly is an area ripe for argument and discussion as the case proceeds. But for present purposes, we're going to admit the testimony.
Is that, so you're finding that this is relevant?
We're not making any finding about relevance, and that's not the stage we are at this proceeding. You can bring your arguments about all the evidence and the relevance of all the evidence at the appropriate time. We're just receiving evidence at this point. The relevancy will be determined in the normal course of the proceeding.
So you're overruling for the record then, you're overruling my objection again, right?
That's correct.
Okay.
Lieutenant, were you on duty with the fire department on the evening of March 1st, 2024?
Yes.
On that date, were you dispatched to a residence on Cranbrook Drive in Clinton Township?
Yes.
When you first arrived, what did you observe at the scene?
I observed a moderate smoke condition inside the residence as noted through the open front door. No signs of any fire or smoke from the exterior that could be seen. The owner of the residence guided us in to confirm the smoke condition inside the residence, and we found an overloaded fireplace with active fire inside of it, contained to the fireplace primarily as far as fire, but being overloaded and the ventilation portion of it obstructed from a chair that was placed within, pushed smoke throughout the residence.
Okay. Who was identified as the homeowner?
Joseph Campbell.
Did Mr. Campbell provide any statements to you as to what had occurred?
He had advised that the chair that was in the fire was placed by him to ward off evil spirits as he had recently purchased the home.
Did you observe any objects to be in the fireplace?
There was normal combustibles that you'd expect to find, from basic paper products and wood materials, natural wood fibers, sticks, and whatnot, and then the chair itself, which was too large and had actually had the back end of it placed up the chimney into the flue section, which was obstructing the proper ventilation.
After you observed the fireplace, what did you do next?
We extinguished the fire, removed the materials, verified that there was no extension of the fire, that the hazard was mitigated, ventilated the residence.
Was there any smoke damage to the home?
There was some minor damage that would have been defined within my report that I know that you guys have in front of you, but nothing that I could see to be extensive.
Were any instructions or warnings provided to Mr. Campbell as a result of this incident?
He was educated on how the chimney works and that it was overloaded, and that performing such actions again in the future could lead to further destruction and fire spread within a residence and be detrimental. And he complied, that he understood that, and there was no indication of him not understanding that from that point forward.
I'm going to, at this time, share my screen with you and show you a couple of documents. Are you able to see that picture?
I am.
Lieutenant? Okay. I'm showing you what's been marked as Petitioner's Exhibit 1, page 1 and page 2. What are these pictures of?
These pictures are of the fireplace within the residence and the surrounding area.
Approximately when were these taken?
Immediately after mitigating the issue and the fire being suppressed, verifying no extension, and the home being ventilated before we cleared the incident.
And are these 2 pages true and accurate depictions of the residence after the fire was extinguished?
Yes.
I would ask that Petitioner's Exhibit 1 be admitted at this time.
No objection.
So admitted.
Thank you. Lieutenant, I'm now going to show you what's been marked as Petitioner's Exhibit 2. There are 2 pages, so I'll show you this page and then the next page. Do you recognize Petitioner's Exhibit number 2?
I recognize that those are photos that I took in conjunction with this incident.
Okay. And what are these pictures of?
The materials that were in the fireplace. It appears to be the remnants of the chair, as well as some of the other natural wood products. And can't make out exactly what the other one is in the bottom left corner. It could potentially be the metal grate that is part of the fireplace and standard that might have been removed as well, just to clear it out completely.
And are these, is Petitioner's Exhibit 2, these 2 pages, are they true and accurate depictions of the chair that was removed from the fireplace in Mr. Campbell's home?
I'm gonna object to that. She's asking the witness to guess. He has no specialized training. He's not a fire investigator. He's not in a position to identify the nature of remnants from a fire. He's there to put out a fire. He's not an inspector.
Ms. Fleming? Perhaps you can simply ask the witness whether these are the items that were removed from the fireplace.
Lieutenant, were these the items that were removed from the fireplace?
Yes.
And when were these pictures taken?
Immediately after the situation was mitigated and prior to us clearing the scene.
I have no objection to that picture being admitted, but I do object to the witness identifying the nature of those items, because he's not really in a position to do that. He's a firefighter. He's not an inspector. I have no objection to that picture being admitted as to him saying that's what he took out of the fireplace. But as far as identifying the items, I don't think he can do that under his skill level.
Well, the exhibit will be admitted on that basis, that these are the items removed from the fireplace.
Thank you.
I don't have any further questions for this witness.
Sanfield?
Lieutenant, how you doing?
Morning.
Could you remove that picture, Caitlin? Thank you. Lieutenant, as I've tried to, you're not a fire inspector, are you?
Correct.
Your job was just to show up and try to put the fire out.
Correct.
But it wasn't really a fire because it was inside, it was contained to the fireplace, right?
The primary fire itself was contained to the fireplace. Heat and smoke had extended beyond the fireplace due to the limited capacity and functions.
No, I understand that. But you already said that. Your response was a smoke alarm went off, and that was the reason your department responded. Is that correct?
I did not state that thus far, but that is what my report states.
Okay. So a smoke alarm went off, you responded, and essentially you found that the flue was partially blocked, so you corrected the problem, put out the fire.
Correct.
And when you put out the fire, it caused the glass screen doors to break, didn't it?
It was at some point upon our activities that I noted the glass to break. I couldn't recall to the second whether it happened when we first touched it, whether when we opened it or when we started spraying water at some point from the time that we got there or that the fire had built in the fireplace until the time that we left the scene and it extinguished the fire. The glass had broke.
This in March, it was probably a cold day, so that wasn't really that unusual to have a fire going on that day, correct?
No, I would not think that it would be unusual to have a fire in a fireplace in March.
Okay, and so basically what the problem was, it was overloaded and the flue got blocked. Is that right?
Yes.
And that blockage of the flue caused smoke. Were the glass doors closed when you arrived?
Correct.
The glass doors to the fireplace?
I would have to.
So what happened was
my belief and remembrance is of that. I would reflect to my narrative and my fire report. I believe that I stated very specifically what my findings were, and I believe that I stated that in there.
right. I think you did as well. Thank you, though. And so when you got there, the doors were closed. The fire was burning, contained to the fireplace, but just it was more of a smoke issue based on overloading the fireplace.
Correct.
Yeah, and you've probably seen that before, haven't you?
I have seen that before.
Is that kind of a common issue?
I don't know that I would say that it's common, but it happens when there's an overloading of somebody that not the appropriate use of a fireplace.
Okay, and didn't Mr. Campbell indicate to you he just bought the house? He wasn't really an expert on loading a fireplace, right?
I have no judgment to be able to know what Mr. Campbell's expertise or experience were. I just know that he did say that he had recently purchased a home.
Okay, and you also stated you gave him like a short course on fire safety and what to do and not to do with the fireplace and how to load it and not load it. And you said he appeared to understand it and didn't have any questions.
Correct.
Thank you, sir. Nothing else. And this goes back to March of 2024, correct? 17 months ago, right?
Yes.
You have no knowledge. You didn't follow up with anything since that date, did you?
There's no knowledge on my behalf of anyone else responding to his residence.
Okay.
That would be something that would have to be asked of the department, and it's above my credentials here. There's multiple shifts and multiple employees, and I personally don't go to every run in the township.
And you've had no contact with Mr. Campbell since March 1st of 2024?
Not to my recollection.
You have no idea how he's doing today or anything, correct?
Do not.
Thank you, sir.
Any redirect, Ms. Fleming?
No, thank you.
Thank you, Lieutenant. Appreciate your time. You are excused.
Thank you.
Getting cold in here. My feet are cold.
I would next like to call Officer Tanner.
Mr. Chairman, what time is lunch?
I'm sorry, Mr. Sanfield, I didn't hear you.
What time is lunch?
Well, I would expect, what time is it now? It's 11:15. I suggest we break for lunch at lunchtime, noon.
Is that noon?
Does that sound appropriate for everybody?
That's fine, right? That's good.
All right.
I mean, I'm hungry now, but that's irrelevant.
True.
Officer Tanner, this is Owen Montgomery, the case manager. Would you unmute yourself and turn on your video?
Who is your employer?
Clinton Township Police Department.
How long have you worked at the Clinton Township Police Department?
4.5 years.
What is your current position there?
Patrol.
How long have you held that position?
I've held it for the whole 4.5 years I've been there.
On August 29th, 2024, were you on duty with the Clinton Township Police Department?
I was.
And on that date, did you have an occasion where you interacted with Joseph Campbell?
I did.
Where did that interaction occur?
It was a business off of Garfield. I do not remember the exact address.
What was the nature of your dispatch there?
I got a call from Mr. Campbell stating that somebody...
Excuse me, officer. I'm going to object to this testimony for the same reasons as the last one. This report's over a year old, so accordingly, I think it's irrelevant as to my client's condition today. And I just think it's irrelevant in general. So I renew my objection as to relevancy with this report and this officer's testimony.
Objection is noted, Mr. Sanfield, and as previously stated, the relationship of these events to your client's current state is a subject of argument and discussion and relevance, and we take that up at the appropriate time. But in the meantime, the evidence will be admitted for whatever weight or relevance it may have.
Very well.
Officer, my question to you was, what was the nature of your dispatch?
Like I said, I got a call, or more so our dispatch got a call from Mr. Campbell. He wanted us to come out and investigate a potential breaking and entering that happened at his business there.
And when you arrived at the location, who was present?
Mr. Campbell was.
Did you meet with him inside the location or outside the building?
When I approached the building, he was coming out of the building as I was approaching that entry door to it.
Did you have occasion to enter the building?
I'm sorry, can you repeat your question?
Did you enter the building?
Eventually, yes.
And how did the office appear at that time?
The office was in disarray. There was multiple chairs that had no tables. Printers were on the floor. Papers were scattered everywhere. Random miscellaneous items like coat hangers, random books and items were all over the place. It was kind of, like I said, a mess and shambles.
What information did Mr. Campbell provide you upon arrival?
That he had affirmation, or more so evidence, that his business was broken into, so he wanted officers on scene to investigate. I can go into detail if you'd like about what exactly he was pointing out.
Okay, let's. What was the initial indication he gave to you to support his belief that there was a breaking and entering at his building?
The first indication he gave was that there was damage to his door that potentially the suspects entered through.
And did you investigate that statement?
I did.
And what did you find?
That there was no... He was alleging there was a crack in the top portion of the door that was not there. There was no crack or movement that officers could see on scene, nor would it be indicative to a breaking of a door to gain entry into a building that would be locked and secured.
And what other indication did he provide to you as evidence to support his allegation that there was a break-in?
The only other evidence he claimed was that there was blood inside the office building.
And did you investigate that statement?
I did.
And what did you find?
The first spot he had me look at was, quote unquote, a chest that had blood on top of it where he kept his Bible. So I went to this chest. It ended up being a podium, and there was a piece of paper with miscellaneous writing on it with a singular red dot. The red dot was not indicative to blood. It actually was ink of some kind, probably from a Sharpie. It was, like I said, not even close to blood. The second spot he had me look at was blood in a random office type room. He said it was under a desk. So I went into that room and looked, and I did not see any sort of quote unquote blood or even red markings that he was alleging was there.
Did you express those findings to Mr. Campbell?
I did.
And was he receptive to those findings?
No.
Did you ask him any other questions while you were present on the scene?
I did.
And what did you ask?
Well, due to his allegations, how he was acting, how he was appearing, I asked him if he had any sort of mental illnesses or if he was under the influence of any alcohol or drugs. Just based on my...
I'm going to object to that testimony. This officer is not a specialist or an expert witness in that field. They should not be allowed to make conclusions as to areas of expertise that he's not qualified.
I think the officer is simply testifying as to what questions he posed to Mr. Campbell. I don't think he's being asked for an opinion about any of that at this point.
He said because of his mental state, he asked those questions. So he's prefacing it with a mental capacity focus, which he shouldn't be doing because that's not his expertise. He's there to determine whether or not there was a B&A, not to analyze an individual's behavior.
We'll take the question as to what conversation he had with the respondent.
And strike the mental portion, correct?
Yes.
Thank you.
What questions did you ask Mr. Campbell?
As I stated before, what was, I guess, objected. That was my main focus. I more so had to get his understanding as to why he was coming to these conclusions in regards to why he thought there was blood in his business and why he thought the quote-unquote damage to the door was indicative to a breaking and entering. It kind of didn't go far because of his uncooperation and his quick acts to dismiss that the police department was trying to help him as he felt we were against him. Despite not only myself, but several other officers on scene, including my sergeant, trying to express to him that...
I'm going to object to any testimony that's not on his personal knowledge, his personal observations.
I think the witness is testifying as to what he heard or overheard at the time. Is that correct, officer?
Correct. It is correct.
You may proceed.
That we all tried to tell him that everything that we had here was not evident, nor was it even, may I say, existing. So, like I said, the conversations really weren't productive. They were more back and forth banter, if you will. And like I said, there was no productivity to it.
Did you ask him about mental illness?
I did.
And what was the response?
It was not receptive. He more so was questioning that it wasn't my business, nor was it relevant to why he called us there. I explained to him that based on what I was getting in my observations and what I was dealing with at the time, with that case in particular, that I had to ask the questions just because everything he was pointing out just was not there. And it did not make any sense on top of when he was talking. The sentences he was forming, or more so the stories he had, were almost seemed fallacy. So that's why I had to express my concern for him and his person and well-being, because I had to add that to my investigation and to my factors of what I had there.
And how did your investigation conclude?
That there was no evidence that would state that there was a B&E, and we did not conduct any sort of, crime scene investigation or like that due to finding no evidence whatsoever to support Mr. Campbell's claims.
I don't have any further questions. Thank you.
Mr. Sampson.
Sir, this is, have you had any contact with Mr. Campbell since August 29th of 2024?
No.
And you say the office was in a state of disarray. Isn't that common on a potential breaking and entering where their office would be in a state of disarray? Somebody breaking in, looking for stuff.
Wait.
I'm sorry?
I lost you. And you said the office was in a state of disarray. Isn't that, and then I'm sorry, I lost you.
Okay, I'm sorry. I'll slow down. Isn't that common though on a potential B&E that a place would be in a state of disarray, stuff messed up and so forth?
In a particular fashion, sure, but this was an organized disarray. I would label it.
Okay, so now you're a disarray specialist.
It's not about being a specialist, sir.
Okay, but when you enter a facility where somebody says, "I think it was broken into," it's not unusual to see the place being messed up, so to speak, or in disarray, to use your term.
Sure, it is circumstantial, but we can go there.
Okay. And nothing else, sir. Thank you.
Any redirect, Ms. Fleming?
No.
Thank you, officer, for your testimony. You are excused.
Thank you.
I would next ask Officer Chomiak to testify.
Okay, I
What
will
was that
admit.
name?
Chomiak?
Showman?
CHOMA. I'm sorry, MIAK.
Okay, I will admit the officer at this time. There's a possibility Officer Chomiak may not be with us right now.
I don't have any further questions of the officer.
Officer Chomiak, are you present? Ms. Fleming, would you like me to put Officer Chomiak back in the waiting room?
Yes, or
Perhaps one of us can reach out to him.
yes, if we may take a brief pause and see if we can get a hold of him,
Okay.
if that's all right with the panel.
Yeah, we'll take a 10-minute recess
Thank you.
at this time.
Okay.
Lynn,
I will
can
open
you
up.
move us to the breakout room, please?
I will do so.
We were
Officer
able,
Sorry, go ahead, Caitlin.
I was going to say we were able to reach Officer Chomiak, so
Okay, perfect.
I know the panel's taking 10 minutes, so we may not be on for a few more, but I believe
Correct.
he's ready when we are ready.
Excellent. Good morning, officer. Your video actually, it looks like it's turned on, but it's just a black screen. Do you have something perhaps covering the video camera? Officer, did you hear my question about whether there's something covering your video camera?
Howdy. So my camera, I guess, is jacked up. This is what I got. So
Okay. I'll let the
pass before.
Do you have another device that you could log in on?
I mean, maybe my phone. That would probably be the only other thing I have in my household. So, and I don't know if that's gonna work here. I tried using it for court Zoom before. It does not work well in my household.
can we try it and see?
Yeah, I mean,
Yeah, I think that would be. I think that would be our preference, is to have video. I'm not speaking on behalf of the panel, just my experience in these matters.
Okay.
Okay.
That better?
Yes. Thank you very much. So I'm going to, yeah, perfect. You beat me to it. Excellent. Thank you. We've got 2 more minutes on the clock. The panel was taking a 10-minute break, essentially to organize logistics. So it'll be 2 more minutes, and then we'll get back on the record.
Good.
Actually, officer, if you wouldn't mind, while we've got this little bit of time in between now and when the panel comes back, let's check the audio, because I know you said you've had issues with this in the past. Maybe we can cross that Rubicon right now. So I suppose, would you tell me what you had for breakfast?
Nothing.
Okay. All right. That's a typical response. Yes. If you could have had breakfast, what would you have had?
Probably cereal and coffee, which I'll probably have at 2 when I get up later. So.
Gotcha. Okay. Cindy, how do you feel?
I can hear him clearly. The picture and the voice aren't quite matching up, but I can hear him.
Agreed. Okay. All right. Thank you again, officer. I think we'll probably risk it, and if we run into any problems, we'll pivot.
Sounds good.
Perfect. Thank you.
Zachary, you look 15.
Thank you.
No problem.
I try to look young.
Does your mother know you're doing this kind of dangerous work?
Yeah, unfortunately, she doesn't approve of it, but.
Okay, the panel's coming back in with us, and let's see. So looks like we have all 3, and I am going to fade in the background.
Yeah, Mr. Sandfield.
We do have Mr. Sandfield. He said he's having some issues with his video cameras. I've noticed that it's come in and out a few times with this white screen. I'm hoping that the white screen goes away shortly.
I am having, what happens is I had to put on some more extensive security software because I was tapped into, and this security software is a little too secure because now it doesn't always turn my camera on. Do you want to proceed without the camera?
Well, that's up to you. We would hate to be deprived of that visual treat, but it's up to you.
But it's not just Mr. Sandfield, it's his client.
True.
Oh, yeah. But he is here.
Yeah, I take your word for it, but I want to see his expressions.
Seriously? Okay.
Don't you think that goes, that's admissible for a hearing officer to take a look at the face of the individual who is supposed to be
there you go. We're back.
All right. Very good.
Good here, Joe.
Okay.
Hey, are we good now, James? Do you see him now?
Yeah, I think we're good.
Okay.
I can see him.
I'll move over a little here again.
All right, I think we're ready to proceed. Owen, you want to check or whatever you need to check here?
Everything is good on my end. You can go back on the record whenever you're ready.
We're back on the record with a witness, and Madam Court Reporter, please swear in the witness.
You know, I actually did go on the record. Do you want me to delete all of that? Because I wasn't sure whether you wanted all that on the record or not. And if I don't put it on, it's lost.
No, that's fine. It can stay.
Okay. All right. I apologize. I'll wait for you to tell me. Okay.
Did you put that on the record when I asked Zach if he was 15?
No,
Okay.
because the panel wasn't present.
Okay.
Okay, officer, would you raise your right hand,
Who is
please?
your employer at that address?
The Clinton Township Police Department.
What is your position with the Clinton Township Police Department?
Police officer,
What are your duties and job responsibilities there?
patrolling and just the normal, obvious police business of a normal day.
On September 3rd, 2024, were you on duty with the Clinton Township Police Department?
I was.
And on that day, did you interact with Joseph Campbell?
I did.
Where did you interact with him? What type of location was it?
A couple office buildings off of Garfield.
What was the nature of your dispatch on that day?
Initially, it was reported as a B&E, which was then changed to a mental complaint based on the circumstances.
Prior to the arrival at the scene, were there any actions taken with regard to the dispatch?
We acquired some information from dispatch regarding earlier calls in the day from the same individual, and one of my commanding officers also spoke to people related to the individual at question about the circumstances as well.
When you arrived at the business, did you make contact with Mr. Campbell?
I did.
And was that inside or outside of the building?
That was outside of the building in his vehicle.
Did you ever enter the building on that day?
I did.
How did you enter the building?
Mr. Campbell requested that we go in with him so he could show us certain things inside the building. We actually had to force entry into the building because he didn't have his keys on him. So, and we door.
And was the building locked?
Yes.
What did you do? What did Mr. Campbell report to you when you made contact with him?
He reported to us that somebody had broken into the building, which was, he had a loft there, and I was under the assumption he was living there. He had made a report earlier in the day of a B&E, which was unfounded. He had claimed he went to Henry Ford Macomb to get treated for touching some blood on a wall. Henry Ford Macomb did not have any record of him ever checking in. And then when we went inside, he wanted to show me and my partner the said blood on the wall.
And when you first entered, what did you observe?
I observed essentially a mess, CDs, papers, miscellaneous documents just scattered.
I'm sorry, officer, that kind of dragged out a little bit. I observed essentially, and then I did
papers, CDs, miscellaneous papers, documents scattered on the ground.
And what did Mr. Campbell want to show you?
He wanted to show me blood that was.
That's a leading question.
Overruled. You can proceed.
You can answer the question.
He wanted to show me blood that was splattered on the wall.
And did he attempt to show you that?
Yes, he pointed directly at the wall and said, "Don't you see all the blood on the wall?"
And what did you observe on the wall?
A wall with no blood on it, just a painted wall.
Did Mr. Campbell report anything else to you?
He also told us that there was a box in the back of his parking lot that somebody had put there and was surveilling him, and it was the electrical box to the building.
During your time at the location, were you able to substantiate his claim that there was a break-in?
No. Nobody had broken in. We didn't the door. That there was forced entry. All the windows were intact.
I'm sorry, you broke up again after nobody had broken in.
Nobody had broken in. The front both the front and the back door were there was no forced entry. All the windows of the building were secure as well.
Did you ask Mr. Campbell directly about his mental health?
I'm going to object to that question. This gentleman is not an expert witness on mental health issues.
The question is, did he ask a question about the respondent's mental health? It's not asking for an expert conclusion. He can go ahead and answer the question.
There were multiple officers there. I didn't personally ask him, but there was questions, something along the lines that was said.
I'm going to object that it's not a personal observation or personal question.
I'm sorry, Mr. Sanfield, I didn't hear your basis.
He can't testify to what other officers might have said unless those officers are heard or did, unless they're prepared to testify today, and I don't think they are. So that would be hearsay without an exception.
I think you can ask the witness if he asked any questions or if he had any direct conversation with the respondent on that topic that he could testify to.
Well, it goes even more. The question was, what did the individual say? And that would be his own statement.
Yeah, that part's okay.
Well, it hasn't been. We're objecting to it. I would like to have the answer to the question, what did the individual say?
Right. He objected to the question of what did the other officers ask him.
Right.
He can certainly respond to what he heard the witness say in response to those questions.
That's agreed.
Officer, did Mr. Campbell make any statements with regard to his mental health?
Yes, he had told me that he had been struck by lightning several times at the location, and he had taken an unknown amount of prescribed Adderall prior to talking to us. Those are the only two comments that he directly made to me.
So you broke up unknown amounts of, and I didn't hear what it was.
Unknown amounts of prescribed Adderall that he took prior to us getting there.
Thank you.
What happened next?
Based on all the comments he was making to myself and all the other officers on scene, we made the decision to petition him and take him to the hospital based on the delusional comments he had made to all officers on scene.
I'm going to object to the conclusion of delusional statements.
Strike the word delusional just based on comments made at the scene.
Were any of the comments that strike that? Once the decision was made, then what did you do?
We took him into custody. We placed him in handcuffs due to him being non-compliant and put him in the back of our police car and took him to the hospital. Once at the hospital, he became more compliant. We took him out of handcuffs and he was fine when we were at the hospital.
Were there any concerns during his transport to the hospital? I'm sorry, I didn't hear you.
No.
And which hospital was he taken to?
McLaren Macomb.
And at some point, did you fill out a mental health petition for Mr. Campbell?
I did.
And why was that done?
Our procedure with the hospital, that it's a court order. It's a court order sheet as well. We can't just take anybody against the hospital against their will. So we have to fill out this sheet every time I take somebody there.
And upon what was the petition based?
based on the splattered blood on the wall and the delusional comments he made while on scene.
Object to the delusional statement.
Suspend, delete, strike delusional comments at the scene.
At any point while you were on the scene, did you see blood?
No.
At any point while you were on the scene, did you see a surveillance box?
No, I did not.
At any point while you were on the scene, were you provided information to substantiate that Mr. Campbell had in fact been struck by lightning?
No.
And during your investigation, did you become aware of Mr. Campbell's profession?
I did.
And how did you become aware of that?
He told us
And what did he tell you?
that he was an attorney.
With regard to the petition for mental health, what was there any concern about Mr. Campbell's ability to stay safe?
I'm going to object to that question. That's kind of overbroad. It has to be based on some facts. This witness cannot testify whether or not there's concern about his ability to stay safe. That would be guessing at most.
Can you rephrase the question, Ms. Fleming, to just ask the facts on whatever document you're talking about?
I can attempt to do so. Officer, you indicated that you filled out a petition for mental health. Is that correct?
Yes.
And within those petitions, an officer is required to make certain allegations to support the petition, correct?
Correct.
Okay. And with regard to Mr. Campbell, do you, was there any assertions made regarding his mental health in your petition?
That's, again, not an issue that this gentleman can testify to.
I think he can testify to what is in the document that Ms. Fleming is asking about, and that seems to be the question.
But he can't testify to the client's mental health.
He's not being asked to testify to the mental health. He's being asked to say what was contained in this document.
Well, that's not what she said. She said, were you concerned as to his mental health? That wasn't a question, as what's contained in this document.
We're past that now, Mr. Sandfield. She's asking about, I assume she's asking about the contents of this document, which she's entitled to ask and he's entitled to answer. So
very well.
Proceed. You may have to repeat the question, Ms. Fleming.
Okay. I'll do my best. With regard to the mental health petition, did you indicate anything with regard to Mr. Campbell's and concerns for his mental health?
That's the same question. I renew my objection.
Overruled. You can testify to what you presumably put into this document that Ms. Fleming is asking about.
What was the basis for it?
Just based on what he told me, seeing the blood on the wall and the comments he made while we were on the team with him, that was enough to have cause for concern.
I don't have any further questions.
Sir, how long have you been a police officer?
Just over a year.
Okay. And you have no specialized training in mental health issues, correct?
Correct.
And are you aware that the petition that you filed for treatment through the mental health court was denied?
No, I was not aware of that.
Were you also aware that after he was taken to the McLaren Hospital, they ran some blood work and he had a consult with a psychiatrist. He was kept overnight, and at the conclusion in the morning, he was discharged with no findings of mental illness. Were you aware of that?
No, I was not.
Okay. So all you know is what you just testified to about responding to the B&E, correct?
Correct.
And the disarray in the office, wouldn't that be indicative of maybe possibly somebody had broken into the office?
And there's avenues that you could possibly argue that, but like I said, there was no forced entry. There was no signs of a B&E.
Well, that's your opinion. But didn't you see? Weren't there pry marks on the door?
No.
Were there pry marks on either of the doors?
No. We didn't observe any forced entry.
So if earlier a police officer testified as to pry marks on the door, that would be incorrect?
In my opinion, I didn't observe any pry marks on the door, sir.
Okay. And when you entered the office, the disarray could be a result of somebody having broken in, correct?
Correct.
And is it possible somebody could go in through like a window or an unlocked door and then leave and close the window and lock the door? Is that possible?
It is possible.
Okay. You don't know if that happened or not, do you?
I don't know, but like I told you, what we observed on the scene, there's no signs of any B&E or anybody forcing their way into that building.
Other than the disarray of the office.
Correct.
Okay. And you didn't do any follow-up with my client since that September date that you appeared, correct?
Correct.
Did either you or any other officers that you're aware of respond to the Clinton Township office for other reports for anything?
I am unaware if anything else happened.
Okay. So, and you weren't aware that your petition for treatment was denied to the probate court, were you?
No.
And you weren't aware of the fact that McLaren Hospital discharged him with findings of no mental health issues, were you?
I was not aware.
No other questions, sir. Thank you.
Any redirect, Ms. Fleming?
I don't believe so.
All right. Thank you, officer, for your testimony. You are now excused.
Thank you, sir.
All right, we've arrived at our lunch hour. It's 12:06. We will recess for lunch until 1:15 p.m. Before we go, Ms. Fleming, do you have a sense of what we have in store from you this afternoon?
I anticipate presenting testimony of Deborah O'Brien, and then respondent, and that will be all.
Okay.
And I can work with Mr. Sanfield and Mr. Montgomery to provide the emails that were requested, as well as the police report that's been admitted. I will mark that as Petitioner's Exhibit 14. I don't think I indicated a number relative to it when it was admitted.
All right. Thank you. We will adjourn now and resume at 1:15 p.m.
Sir, just so I'm clear that at the conclusion of this case this afternoon, I'm going to be given the opportunity to bring forth that witness, correct?
You will be given the opportunity to assess your need for that witness, and if you so determine, you will be able to, assuming that everyone's finished with their cases today,
okay,
and we close, you will be given the opportunity to come back for that witness.
And would I also have the option of bringing back the psychologist if the report is available when we return?
Well, that's a different issue. That we're not addressing that issue at this point. Okay, we don't know anything about a psychologist.
We can address it at the end of the day, at the end of the hearing, right?
Well, why don't you see if you could work something out with your Ms. Fleming on that point to avoid us having to deal with that. If you can't, we'll deal with it.
Gotcha. Have a
All
great.
right. We will
Thank
see everybody at 1:15. Thank you very much. We are off the record.
Thank you.
Thank you.
You, Owen. Apologies for the delay. We had a few technical problems at this end, but I think we're ready to go. So we will go back on the record now, and Ms. Fleming, you can call your next witness.
The next witness is Deborah O'Brien. And how are you employed currently?
I'm an attorney.
And how long have you been a licensed attorney?
I hate to say it out loud, but 42 years.
And what type of law do you practice?
I have practiced exclusively family law for about 25, 30 years right now.
And are you familiar with Mr. Joseph Campbell?
Yes.
How are you familiar with him?
Well, I represented Gina Belcastro Campbell in the divorce action in 2022, and then I've been involved in post-judgment proceedings.
During the divorce prior to the judgment of divorce, how would you describe the proceedings between the parties?
Well, I actually thought the proceedings were fairly friendly. We resolved the case at mediation, entered a consent judgment of divorce. The parties were granted equal parenting time, which showed that they were working well together.
Hold on.
That's
Sorry, one at a time, please.
Can I object to relevancy?
Yeah, I know, but you speak right over the witness, and then I can't hear either one of you.
Mr. Sandfield, do you have an objection?
Yes, that it's irrelevant what took place 4 years ago.
All right, noted. You can argue relevancy at the appropriate time. This testimony can continue. Please go on, Ms. Fleming.
Thank you. Ms. O'Brien, you indicated that you're also assisting Ms. Belcastro in post-judgment proceedings, correct?
Yes, that's correct.
And where is that matter being heard?
That's heard in Macomb County Circuit Court, and the current judge is Rachel Rancilio.
During the post-judgment actions, has there been a period of time where Mr. Campbell represented himself in the proceedings?
Yes, there have been a couple of times. He represented himself from about October 2024 till January 2025. Then Mr. Sandfield was involved until March 17th, 2025, when he was allowed to withdraw. And then there was a time frame for a couple of months where Mr. Campbell was unrepresented, and then Mr. Sandfield is now back in.
Okay. And going back to October of 2024, were there court proceedings relative to the divorce action that were filed in 16th Circuit?
Yes, we filed an emergency motion regarding custody and parenting time on October 1st, 2024. And we had all kinds of allegations regarding concerns pertaining to Mr. Campbell at the time.
With regard to Mr. Campbell's self-representation as an attorney with over 40 years of experience, did you have any concerns about him representing himself in the proceedings?
I'm going to object. This witness is not an expert in the areas of ability to self-represent yourself based on your mental condition or anything else. That's not a factual issue before this panel. And just because she's been practicing 40 years doesn't mean that she's in a position to respond to that question. She's not an expert.
Are you offering Ms. O'Brien as an expert on any particular topic, Ms. Fleming?
I'm not offering her as an expert. I asked the question relative to her experience in the proceedings and in the profession.
That's really that's not an appropriate question.
I'm happy to hear. I think we're happy to hear Ms. O'Brien's testimony as to what she observed, what she heard, what took place. in terms of factual observations and discussions. I think you need to rephrase that question a little more focused if you can.
Ms. O'Brien, you were present at a proceeding on October 15th, 2024. Is that correct?
Yes.
And was Mr. Campbell present for that proceeding?
Yes, he was.
And was Mr. Campbell representing himself at those proceedings?
Yes.
And what did you observe at the proceeding on October 15, 2024, relative to Mr. Campbell representing himself?
I'm going to object to that. That's overbroad. That calls for a narrative.
I'll take the answer.
Well, I observed what I considered to be someone who was having difficulty representing himself, who was speaking in a manner that I perceived to be nonsensical and not someone who was, I think, proficient in the type of practice or even in representing what his interests were. I was concerned for him. I was very concerned for him, and I was saddened by it. My response to it was to be very gentle with the man. And the fact of the matter is I felt that the whole experience was nonsensical and odd, as were his pleadings.
Again, I think that should be strict, and that doesn't answer the question. Those are not factual observations. They're all conclusions, and they're not really supported by anything other than this witness's own statements, who happens to be the opponent on the case, where she represents the spouse, the former spouse, in a case trying to affect my client's parenting time. So she's far from neutral, and if she's going to be a witness, she needs to state factual observations, not just conclusions.
Ms. Fleming, I think Mr. Sandfield has a point. I'd like you to focus your questions on specific observations, interactions between Ms. O'Brien, Mr. Campbell that are factual in nature, the realm of what all that might mean or what import it may have is really for the panel to determine. So if we could focus on actual exchanges, so forth, that would be helpful. Okay.
At the conclusion of the hearing in October, did the court make a ruling relative to your emergency motion?
Yes, the court entered what's called an interim order and gave it immediate effect. The referee who heard that motion, Referee David Falk.
I think that document is hearsay unless, Caitlin, is that one of the exhibits that was certified?
It is Exhibit 9, I believe is what she is referencing.
Take a look, see if it's Exhibit 8.
Which exhibit is it?
Exhibit 8 is the transcript relative to the proceedings that were heard on October 15, 2024. Exhibit 9 is the recommended order that was entered.
Thank you.
Are you asking me to testify as to what the order was?
No, we have that in the record relative to and after that proceeding, what happened next?
After that proceeding, Mr. Campbell filed objections, and I believe he filed a motion. He filed two different motions. One of the motions was to dismiss the case for the court's lack of jurisdiction for an improper formation of a family court. And the other motion was for custody to be awarded to him, custody and parenting time to be awarded to him, for a writ of habeas corpus to release the child, and for a personal protection order, all in the same document, all in the same filing.
And I'm going to share my screen in a moment. Do you see that document?
Yes.
And is this one of the pleadings that you were just referencing?
Yes.
And then I'm also going to show you once I get there. So with regard to the verification that Mr. Campbell signed, do you see that note underneath his name that says as next of friend?
Yes.
Do you know what that could be in reference to in your proceedings?
I'm going to object to that. On my copy, it says as next of, it's blacked out.
As next friend. And for the panel's reference, or for the record, there are references in this document to a minor child. And so that is why the information is redacted, as well as some personal identifying information. If there are questions about the redactions, I can certainly address those.
You can't testify to stuff that's blacked out. Expect me to, how do I cross-examine that? Just go by your statement.
My question, I believe, was as next friend of. I don't believe I indicated a name.
I do see that. Is that if that's your question?
Okay. Was he appearing on behalf of anyone else besides himself at that point for the proceeding?
Not that I'm aware of.
That's if she knows.
Well, he represented himself in the motion. I am not aware that he appeared on behalf of anyone else.
Okay. And now I'm going to show you what's been marked as Exhibit 11. Was this also one of the documents that you referenced in your testimony? It may take me a moment to scroll through.
Yes, it is.
And was there a hearing in November that you observed Mr. Campbell at?
Yes, there was a hearing on November 12th, 2024 in front of Judge Jokic, and it was on his motions and his objections to the front of the court interim order of October 15th, 2024.
And did you observe anything at the hearing that would cause you concern?
Objection, it's overbroad, and she's not in a position to answer a question like that. I don't know what is meant by concern. She can only testify as to facts, and she can't give expert opinions.
Ms. O'Brien, can I rephrase?
Please do.
What did you observe at the hearing in November of 2024?
Yeah, I'm going to agree. That's overbroad.
Let's proceed. She can answer the question.
I observed Mr. Campbell to be animated in his response. I observed him to be very respectful to the court, to the point of something that seemed odd to me. And I observed his language to be nonsensical.
I'm objecting again. This is not factual. This is conclusion.
And meandering.
These are improper conclusions and should all be stricken.
It is what I observed on his in conversationally in his presentation of his argument.
That's not factual.
Mr. Sanfield, please don't address the witness.
Okay, sorry. I just known her.
Your objection is noted. We'll take the testimony. You can argue about its relevance or pertinence later.
Ms. O'Brien, has the domestic proceeding addressed Mr. Campbell's mental health in any way?
It has. And if you look at the court orders that were entered, you'll see that on the first order of October 15th, 2024, the referee specifically states that he believed on the record there was sufficient evidence and of a threshold issue causing concern for the court to reconsider custody and parenting time. That's specifically in there. Then I have to just tell you that it unfortunately was an obvious thing in my observation, that there was clearly a disconnect between what Mr. Campbell was attempting to argue and how he was arguing it in front of the court. He did not seem to be the same man that I knew in the divorce proceedings. It was very sad to me.
And I am going to share my screen again with you. That it appears as though the hearing was held on April 15th, 2025. And can you confirm at that point, did the court order a psychological evaluation and a substance abuse evaluation?
Can I interrupt just for a second? We're talking about a particular exhibit, is that correct?
I'm sorry, Exhibit 12.
And this is something that you're asking her to refresh her recollection, or you want to admit this?
It's been admitted.
It's admitted.
It's already admitted.
Yes, sir.
Okay. Thank you.
I'm sorry. What are you asking me?
Ms. O'Brien.
Continue now.
Ms. O'Brien, was this the first order that Mr. Campbell was ordered or requested to obtain an evaluation relative to his mental health in the domestic case?
It was the first order. It was a result of my having filed a motion and asking the court to order it. And the court did so. They gave us a couple different options of doctors for the psych evaluation and for the substance abuse evaluation. And then after that, there was another order entered after I filed another motion, and he was specifically ordered to attend appointments with Dr. Richard Wooten for a psychological evaluation and for substance abuse evaluation.
And Ms. O'Brien.
I'm sorry.
Ms. O'Brien, I'm going to show you what's been marked as Petitioner's Exhibit 13. I'm going to attempt to. Is this the order that you were just referencing, where Mr. Campbell has been ordered to complete an evaluation with Dr. Wooten?
Yes, when he did not reach out to any of those doctors that were recommended or suggested as potential evaluators in the earlier order of April, I filed a motion to compel his appearance in front of Dr. Wooten, and the court did order that. He was ordered to appear for an appointment on June 23rd and to comply basically with the rest of the requirements of the doctor to complete the evaluations for psychologically and also for substance abuse. I had also filed that motion on the basis of other problems that were ongoing, and that became a final order on June 10th, 2025. There were no objections filed to that order.
Do you know when that evaluation, or approximately when that evaluation is expected to be completed?
It's my understanding that it typically takes about 2 months to complete the testing and all of the report writing, and it's supposed to be available at the end of this month. That's what I understand.
How have you observed any correlation between the court's findings that you referenced of Mr. Campbell's mental health and his visitation?
I'm going to object to that. She can't talk about mental health issues. She's not an expert in that field.
I can tell you that I have filed other motions.
Hold on, Ms. O'Brien, please. objection's been made. I don't believe the question is asking for an expert opinion on mental health issues. I believe the question is what was the question? A correlation between mental health issues and visitation. Yeah, I certainly want to be careful here about treading into diagnosis or other things, but if Ms. O'Brien can answer the question from an observational basis, then we're happy to take it.
But she can't really respond to the mental health portion of that question.
I didn't hear a medical portion of it.
She said, can you create your mental health analysis in conjunction with those orders? That's basically what she said. That does require an expert.
I don't think that's true, Mr. Sandfield, and we'll proceed with her observations along those lines.
A brief interruption. We're expecting that we're going to get an exhibit and evidence relating to his psychological status in this proceeding. Is that right?
Well, that was the document that I asked for an adjournment for because it's not completed yet.
Okay. But there's going to be a mental health evaluation that's going to be admitted in evidence at some point. Isn't that right?
That remains to be seen.
It's court ordered. It will be admitted.
It's court ordered. It's court ordered for circuit. It's court ordered for circuit court, but it's not court ordered for this panel.
Well, the witness isn't going to be responding to that. It's my understanding that a court order, a judge can take a judicial notice of a court order if it's relevant. And if that is presented and the prosecution or the ADB decides that they want to offer it, do we expect to have that offered, Ms. Fleming?
So I think this is getting into a little bit as to, so some information has been provided to the panel already. So I anticipate
talking about the anticipated evaluation. Okay.
I don't have I'm sorry.
Which is a part of what is the exhibits that you presented and that we've admitted, refer to it. Do you intend on offering that when it is prepared?
I don't have assurances that it would be made available to me. I think it's within the panel's discretion to order that it be produced in these proceedings, but that's where we stand relative to the report and evaluation.
Okay, so that's not really clear to me then. Mr. Shanfield, you've asked for an adjournment based upon the fact that $5,300 has been paid for an evaluation that you are anticipating, and the adjournment, if it's predicated on that, do you intend on introducing it when it comes in?
Well, first of all, the request for an adjournment based upon that was denied, so I don't think that's a fair question. If the adjournment
it's a fair question because it has not been denied, it is still being under consideration. So if it is adjourned for the purposes of having you have time to evaluate the witness and determine what is going to be in the psych evaluation, do you intend on offering it?
I don't know at this time.
Okay. So
how can
I'm sorry, I'm speaking.
How can I answer something I haven't seen?
Mr. Chairman, I've asked enough questions. I'm satisfied that we can go forward.
Thank you. That was very helpful. Ms. Fleming, Ms. O'Brien, please continue.
Ms. O'Brien, I apologize. I'm not sure if you answered the question relative to have you observed a correlation between the parenting time orders and the court's findings relative to Mr. Campbell's mental health?
Objection. We're getting into the mental health issue again.
I don't think we are, Mr. Sandfield. The question is straightforward. The court made some decisions about parenting time. The question is, did the court correlate those decisions with some issue of mental health that the court referenced in its order. So yes, Ms. O'Brien, you may answer that.
Yes, there is clearly a correlation. I filed 3 motions that all raised issues regarding the conduct of Mr. Campbell, and as a result of each of those motions, his parenting time was curtailed and reduced. And in the most recent order, he was admonished for his conduct in violation of the supervision requirements of his parenting time. He was admonished not to show up, pop up. He was admonished just at the minor child's home. He was basically told he had to abide by the parameters of the supervised parenting time, and he lost his Thursdays as a result. So he has parenting time on alternating Saturdays and Sundays now, whereas in the beginning he had parenting time on 3 days a week. Now it's 1 day a week. And I'm not sure if you have that court order, but it directly addresses his conduct to the point that either his conduct was the manifestation of a mental health issue or his conduct was the result of his intentional disregard of court orders, because he's taken the position that he's totally fine. So either he's intentionally disregarding the parameters of his supervised parenting time or his conduct was the manifestation of the problems we've brought to the court's attention.
At this time, Ms. O'Brien, does Mr. Campbell have any unsupervised parenting time with this child?
He has none. And in fact, the orders, each consecutive order has made it more clear and more
I'm going to object. This is a yes or no question. This doesn't call for all this expounding on it and trying to indicate things that aren't.
Fair enough. Ms. Fleming, proceed with direct, please. Ask the questions as on a direct manner.
He does not have any unsupervised time with his child presently, correct?
He does not.
Thank you. I don't have any further questions.
Mr. Sanfield?
Ms. O'Brien, how are you?
All right, thanks.
Now, you're clearly here. Your client is the opponent to my client on this parenting time issue, correct?
Yes.
And your objective in the circuit court action is to attempt to seek relief based on what you've been informed by her, correct?
Yes.
Okay, you have no personal information or knowledge of anything in those pleadings. You've just done what your client hired you to do, correct?
Actually, I've had made personal observations regarding Mr. Campbell's conduct, and I thought he was my best witness, unfortunately.
Okay. Now, when you referred to the October 15th order from David Falk, he's a friend of the court referee, right?
Yes, he is.
And he made a finding that he thought that there was some mental concerns, therefore he modified the parenting time, but that's based upon a showing that the best interest of the minor child prevail, not necessarily what's going on with the father, correct?
I don't know what you mean by that, because what was going on with the father is the reason the child had to be protected.
The best interest of the minor child are the prevailing basis for a motion to modify parenting time, correct?
No, I think that's an inaccurate recitation of the law.
These are yes and no questions. I know you want to lay it on thick for my client, but I want you to answer these yes or no.
Counsel, just let's proceed with dignity with the witness, please. You don't have to argue with the witness.
I'm not arguing.
You answered the question, no. What's your next question?
Okay, so you agree that David Falk, as a friend of the court referee, is not really an expert when it comes to mental illness, is he?
I'm not aware that he is.
Right. His role in this is a friend of the court referee, just hearing the case and making a recommendation to the court, correct?
My understanding is that's what his job is, yes.
And that's what he did on October 15th.
Yes, he took testimony, he listened to the argument, and based upon what he heard.
That's a yes or no, counsel. Yes or no?
Yes.
And you were the one that suggested Dr. Wooten, correct?
Actually, I had suggested many different people.
Yes or no, counsel? You were the one that suggested.
I can tell you that's not accurate.
Okay, let me backtrack. On the final hearing.
I can tell you who I suggested. Would
On
you
the
like to know
last
what I
hearing-
suggested?
And the hearing where the order was ultimately entered, that says Dr. Wooten is to conduct a psychological and substance abuse evaluation, that was at your request, correct?
No.
You said that's what you testified to.
The
Wait,
psychological evaluation.
Hold on.
Oh, yeah.
Please.
Please, I can't take you both at the same time.
All right.
Let me
The
rephrase it. Counsel,
Let's slow down. Let the question be asked. Ms. O'Brien, Mr. Sandfield, listen to her answer. Let's proceed.
counsel, didn't you state that because there was a difficulty in selecting a counselor, you filed a motion to clarify that and requested that Dr. Wooten be selected, and the court made that recommendation and agreed with it? Yes or no?
No, that's not what I said.
Okay. Now, Dr. Wooten was somebody you suggested, correct?
That is not what I said. No.
I said, was Dr. Wooten one of the people you suggested?
I believe at the hearing, it was the suggestion of the referee. That was referee Karen McDonald. You were not his attorney at the time. And she suggested 3 different people who are listed in the court order. I contacted all 3 of those people, and only Dr. Wooten was available to do the evaluation.
Well, that's what I asked you. Then you filed another motion and asked that he be appointed to do the evaluation, and he was. That's what I asked you. You said no.
That is not what you asked me, sir.
All right, let's not argue. I think we get the gist of this. Move on, Mr. Sandfield.
Okay. Now, this motion was when? October of 2024, correct?
The initial motion was filed on October 1st, 2024.
Okay. Now, how much does Dr. Wooten charge for this report?
It's my understanding that he's charging approximately $5,300.
And did my client pay for half of that?
I don't know.
Do you know whether or not the evaluation's been paid for?
I think it has been.
Right. And how much did your client pay?
She paid half.
Okay. So then can we summarize that? If she paid half and you think it's been paid for, can we then conclude that the other half has been taken care of by my client?
I don't think so. I think it may have been paid by his parents.
Oh, thank you for that. Now, your objective in this circuit court proceeding is to attempt to substantially affect my client's ability to see this 4-year-old child, correct?
My objective, it cannot be characterized simply by that statement. I would say my objective is to ensure the minor child is safe when he's with his dad, and I want dad to be healthy and able to parent properly.
And
That's
you agree my client is passionate about seeing this child, right?
Oh, yes.
He's insisted he wants as much parenting time as possible, doesn't he?
That's what he says.
And do you agree with that?
Agree with what?
That it appears as his objective?
It appears that he wants as much parenting time as he can get.
And prior to you filing this motion, didn't he have a 50-50 parenting time unsupervised?
He did.
Okay, so you've substantially chipped away at that, haven't you?
I have not chipped away at that. It's been a court order after hearing and objections, everything else that is chipped away.
Who was the plaintiff?
On the basis of his conduct brought to the attention of the court.
You represented the ex-wife in every one of the motions, right?
Yes.
And every motion started out with one motion to affect the 50-50 parenting time, and it spiraled from there to the point where now he's down to 1 day supervised, correct?
That's correct.
And didn't he represent himself on some of those hearings and do what we would describe as a less than scholarly job?
He represented himself on, I want to say, 2 of the 3 motions, or maybe 2 of the 4 motions I filed. And as I told you, he was my best witness.
So you think he would have been best served by having his own attorney for that as opposed to representing himself?
I don't know that it would have made a difference if he had had an attorney.
But that isn't the question I asked you, counsel.
you asked me if he would be better served. I don't know if he would have been. I don't think so. I think it was obvious.
And once the Dr. Wooten report is received, if it's favorable towards my client, is your client willing to expand on the parenting time based upon that?
Objection relevant.
Yeah, I don't think this is the form in which to litigate the child custody matter, Mr.
I'll withdraw that question.
Mr. Sandfield, you have to let people finish speaking because I can't get you both. I just absolutely cannot. And you talk over people and I can't make a record.
Madam
Okay, I'm sorry, Mr. Guerrero, but it's really very frustrating.
I understand.
I'm trying to hang on.
Let the record reflect that Mr. Sandfield withdrew the question.
That's correct. And you still represent his ex-wife, correct?
Yes.
Okay.
That's all. Nothing further. I think so. Yes.
I guess I'm good for now. Thank you, counsel.
Any redirect, Ms. Fleming?
Can I ask a question? Can you please sit back so that we can see the respondent?
Oh, I'm sorry.
Or if you could, move your screen so that it takes him in.
Thank you, Mr. Thomas.
Maybe let's see. Good point.
No, thank you. Oh, you're doing fine. There you go.
Is that better?
You tell me. Take a look.
Looks better.
Thank you.
I'm going to have to go to photography class.
This isn't your first Zoom, is it?
I've done a few.
Okay.
But usually I don't have a client. Usually I don't have a client.
Fleming, do you have any redirect?
I don't. Thank you, Mr. Trevorson.
Ms. O'Brien, thank you very much for your time today. You are excused.
Thank you.
Ms. Fleming, you can call your next witness.
Thank you. I'd like to call Mr. Campbell next.
Can you see my client good enough here, the way we're set up now?
I'll let you know if I don't.
Maybe I should put it up a little bit so you can see him, his whole head. Would that be better?
I think we're fine now.
Okay. And what I can see, I only see his forehead, but that's okay.
What type of address is that? Is that a residence?
Residential, yes.
Is that, you've heard testimony today about a house fire that occurred in March of 2024, correct?
Yes.
And is that a different address that than where the house fire occurred that was testified to earlier?
Yes. I also am working out of the law offices of Gary Sandfield.
What type of law work are you doing at this time?
The Joseph Campbell Justice Center is working, is now located in the law offices of Gary Sandfield.
Okay. And what
let me just clarify that. Joe wants to use my address for mail and stuff, but I can honestly say that no cases are being represented or handled out of my office. He's handling everything out of his residence in Macomb Township.
That's right.
Is that right, Joe?
That's right.
Okay.
What type of law practice do you have, Mr. Campbell?
I am a specialized criminal defense litigator, driver's license restoration litigator, as well as a civil rights 1983 violation litigator, and a personal injury litigator, as well as a water law litigator.
As part of your practice, do you advise clients?
Yes, Ms. Fleming.
And as part of your practice, do you appear in courtrooms?
Yes.
And as part of your practice, do you discuss pleas or potentially going to trial with clients?
Yes.
I'm going to share my screen. Are you able to see that court record, Mr. Campbell?
Caption: defendant's emergency motion to cancel bench warrant and reset for hearing.
Yes, you see that document.
Yes.
Okay. And who is Justin Eric Donaldson?
A former client.
And I note that under your name, it indicates that you are the attorney for the plaintiff. Do you see that?
Yes.
And in this case, State versus Justin Eric Donaldson, were you the attorney for the plaintiff?
No.
And on this next page, you indicate that you were struck by lightning and sustained injuries that required hospitalizations and continuum of care medical services. Do you see that paragraph?
Yes.
Okay. And how many hospitalizations did you have relative to this allegation?
1.
And what was the continuum of care medical services that you're referencing in this motion?
No heavy lifting.
And at the bottom of this document, there is reference to a Mr. Donaldson. Do you see that at the bottom of Petitioner's Exhibit 3?
Yes.
Paragraph 6. Is that your client or in reference to someone different?
My client at that time.
Okay. And you indicated that in this motion that you would be able to make it to both in-person and Zoom court appearances on behalf of Mr. Donaldson, correct?
Correct.
Okay.
You'll pull the chair to block.
Oh my good. I can read from a distance.
And I'm going to show you next what's been marked or attempt to.
Is that Exhibit 4?
As Exhibit 4. And do you see Petitioner's Exhibit 4? Mr. Campbell?
Defendant titled caption entitled defendant's emergency motion to cancel bench warrant and reset for hearing.
Okay. And again, you represented Mr. Donaldson, correct?
Correct.
And he was the defendant in this case, correct?
Correct.
Okay. And looking at your answers to the petition, you indicated that you could neither admit or deny that the emergency motion contained reference to the lightning strike, hospitalizations, and continuum of medical care. Do you recall that answer?
Will you please repeat the question? Will you be more specific?
I'll ask it a different way. You also, in this motion, indicate that you were struck by lightning, correct?
Yes.
And you also indicated that it required hospitalizations and a continuum of care medical services, correct?
Right.
And are these different hospitalizations than the first motion that I referenced, or new hospitalizations?
Neither.
Okay, what hospitalizations were you referencing in this motion that you filed in Sixth Circuit Court?
The one hospitalization, the one and only hospitalization.
And what was referenced, what were you referencing when you indicated a continuum of care medical services?
You asked and answered that question.
I think that was in reference to Exhibit 3. This is Exhibit 4, filed in a different court.
Mr. Stanfield, could you answer my question?
You want me to answer the question?
Mr. Campbell.
Oh, okay.
Ms. Fleming, are you asking me whether or not I was hospitalized in any additional times but for the one that I already placed on the record?
I'm asking you relative to this motion in Sixth Circuit, what were you referencing when you included a continuum of care medical services?
No heavy lifting.
I didn't hear that answer.
No heavy lifting, Mr. Thomas.
And I'm now going to show you what's been marked as Petitioner's Exhibit 5, which was filed in 40th District Court. Do you see that document, Mr. Campbell?
I do.
Okay, and this is in reference to the same former client, Mr. Donaldson, is that correct?
Yes.
And even though it indicates that you're the attorney for the plaintiff, your client was the defendant in this case, correct?
It's captioned defendant's emergency motion, correct?
And again, this filing indicates that you were struck by lightning and sustained injuries that required hospitalizations and continuum of care medical services. Do you see that paragraph?
Yes.
Okay. And in that paragraph, you indicated that there were, that you required hospitalizations. What hospitalizations are you referencing when you filed this motion in 40th Circuit, or 40th District Court, excuse me?
It's a typo. It should have been a singular hospitalization, not plural.
And with respect to continuum of care medical services, what were you referencing in this motion?
No heavy lifting.
So your filings with the court, when you then indicate that your injuries made you unable to keep Mr. Donaldson reasonably informed of his court dates, that was in reference to hospitalizations and your inability to lift heavy objects?
With hindsight being 2020, I believe that was an overstatement or an untruthful statement because, in fact, Mr. Donaldson refused to answer my phone calls after I repeatedly attempted to contact Mr. Donaldson and keep him in abreast and communication as required by the Michigan Rules of Professional Conduct. I was unable to do so, not because of my injuries, but because of Mr. Donaldson's not unwillingness to communicate with me.
Do you acknowledge that those statements were not truthful to the court in each of the motions?
I acknowledge that I overstated my zealous advocacy was an overstatement. It was an overstatement of zealous advocacy. Yes.
Based upon the exhibits 3, 4, and 5, do you acknowledge that you made assurances to each courtroom that you would be able to appear in the future in representation of Mr. Donaldson?
I think the document speaks for itself, counsel.
With reasonable accommodations.
In 40th District Court, did you subsequently fail to appear on Mr. Donaldson's behalf?
Yes.
And that resulted in contempt proceedings against you, is that correct?
I also appeared on behalf of Mr. Donaldson. He failed to appear. At least once, perhaps twice.
That wasn't my question. Did your failure to appear result in contempt proceedings against you, Mr. Campbell?
Was there a contempt of hearing, a contempt of court against me? Yes.
And
By the way, I don't think that's a proper analysis, counsel. It wasn't a contempt of court proceedings. It was a show cause. Counsel knows that's mischaracterized.
Mr. Sanfield, you'll have your chance to address what you consider discrepancies on your examination of Mr. Campbell. You don't need to speak to that now. Proceed, Ms.
Thank you,
Fleming.
Mr. Guerrero.
Yeah. Did you ever appear in person in Sixth Circuit Court after filing your emergency motion?
I attempted to.
Did you ever actually appear in person or by Zoom in Sixth Circuit representing Mr. Donaldson in Sixth Circuit Court?
I attempted, I believe I dialed in remotely. And the case was adjourned due to judicial economy. In the interest of judicial economy.
Did you complete your representation of Mr. Donaldson in Sixth Circuit Court, or did another attorney substitute in on your behalf?
Another attorney substituted in on the case on my behalf.
With regard to Third Circuit Court, did you ever subsequently appear after filing your motion on behalf of Mr. Donaldson?
Isn't that the same question, counsel? You said, did he ever appear? Did he ever appear in the Sixth Circuit? Isn't that the same question?
Third Circuit.
Oh, third. What's that? Wayne County?
Wayne County Third Circuit Court.
Due to the client's unwillingness to communicate with me and a breakdown in communication with Mr. Donaldson, I was unable to appear on his behalf without the client being present.
I'm going to share. Sorry, I should have kept my screen open. I'm showing you, Mr. Campbell, what's been noted as Petitioner's Exhibit 6. Do you see that document?
Yes.
And what is that document?
An email.
And this was the email you submitted as an answer to investigation, correct?
Could you scroll up to the top, counsel, so you can see it? Like the caption there. There you go. A little higher. Okay. Here. That's the request for investigation answer.
Yes. Am I the author of the email?
Is this the email you provided in answer to an investigation?
Yes.
I would ask that Exhibit 6 be admitted.
Any objection?
No objection.
I'm sorry?
No objection.
So admitted.
Thank you. Mr. Campbell, you identified or indicated in this document that you were in a house fire and that you were struck by lightning. With regard to being struck by lightning, were you ever requested to provide information to substantiate that claim?
That's I'm going to object to that. That's attorney-client privilege communications.
The question was he ever requested to provide substantiation of his claim of being struck by lightning? Did I hear that correctly?
You did.
Yes, but let me give you an offer of proof, though. It was never said. He was never received any of that personally, I don't believe.
Correct. That's right.
I'm afraid I don't understand the objection.
Well, he answered the question, so we're good.
I didn't hear the answer to the question. What was the answer to the question?
He asserted privilege. There's still a question outstanding. Can you make a basis for privilege here, Mr. Shanfield?
Well, so by offer of proof, the question is whether or not was he advised to substantiate that, and
that's not the question, Mr. Sandfield. The question was simply, was he ever requested to provide substantiation for his claim? That's the question.
Okay, now the question is that directly to him or is that through my office?
That's not the question. The question was to Mr. Campbell. Were you ever asked to provide substantiation? Yes or no? You can answer the question, Mr. Campbell.
Yeah. By whom? By whom, Your Honor?
By anyone other than a privileged person.
No.
The request for investigation was by the AGC. Did the AGC request verification of what it is that you were saying?
To my attorney.
That's not privileged if they request verification.
Well, if you're asking for a hospital report, that's a HIPAA and a privilege question.
Nobody said anything about a hospital report, Mr. Sandfield. Mr. Campbell, did anybody ask you for any proof or substantiation of your claim of being struck by lightning? Yes or no?
Yes, Ms. Fleming.
Ms. Fleming asked you for that. Okay.
Yes.
Now we can move on. Ms. Fleming, continue.
Mr. Campbell, did you ever submit information to confirm or substantiate your claim that you were struck by lightning?
May I have a sidebar with my attorney, please?
You're on the witness stand. Wait a second.
Yeah.
He's on the witness stand under oath.
Answer the question, please, Mr. Campbell. Mr. Sandfield,
yes,
you're on.
The answer is that I in fact, I did submit information to the 48th District Court to that effect.
40th.
That's not the question, Mr. Campbell. The question is, did you respond to the Attorney Grievance Commission request?
No.
Yes or no?
No.
Ms. Fleming?
Yeah. And Mr. Campbell, you're currently court ordered to complete a psychological evaluation / substance abuse evaluation in your domestic matter, correct?
Family. Yeah, the family division matter. Yeah. Yes.
And you appeared for a sworn statement as part of the investigation, correct?
Will you please repeat the question, Fleming?
You appeared for a sworn statement at the Attorney Grievance Commission as a part of the investigation, correct?
Correct.
And that sworn statement was rescheduled a couple of times at yours or your counsel's request, correct?
I cannot recall.
Do you recall at your sworn statement denying that you have any mental health diagnosis?
No, I do not deny that.
You deny you have mental health because you don't have mental health.
Right.
Excuse me.
Wait, whoa.
Mr. Sandfield.
This has to stop.
This is not a deposition. This is sworn testimony on oath. You cannot coach your client while he's giving these answers to the grievance administrator.
I don't think he understood the question, though.
Well, then you can take the appropriate steps through Ms. Fleming to clarify, but you cannot coach your client during his testimony. Is that understood?
Yes, sir.
Thank you. Proceed, Ms. Fleming.
Mr. Campbell, at your sworn statement, you testified that you had no history of mental illness, correct?
Correct.
And do you want to amend or modify your statement in any way today relative to mental illness?
No, ma'am.
You also indicated at that time during your sworn statement that you were not seeing a therapist or a mental health provider, correct?
Correct.
And is that still true to this date?
Correct.
Wait, you're asking, wait a minute, I'm going to clarify that. Is he seeing, you're saying, is he presently seeing a mental health? Clarify that again, counsel. I didn't understand that.
He answered
Brian
it.
has answered the question, Mr.
He answered it.
Sandfield.
Let's move on.
Move on, please.
I don't think I have any further questions for Mr. Campbell at this time. I would defer to Mr. Sandfield or the panel.
Mr. Campbell.
No, hold on, Gary, hold on. Can we go into a breakout room for a second? I'd like to discuss something with you.
Sure.
You talking about with me or
We're going to take a short.
I just signed up. Is Diane Street asking my client questions?
We're going to take a short recess for the panel to
Off the record.
convene separately. 5 minutes. We'll be right back. Owen, can you please move us to a breakout room?
Yes, sir. Okay, looks like we have everyone. I'm all set on my end. Back to you, Mr. Guerrero.
Don't see our. There we go. Okay, we're back on the record. You can proceed, Mr. Sandfield.
Did you switch seats or positions?
No, Mr. Sandfield. Please proceed.
Okay. Well, I mean, you're not in the center any longer.
Well, that's your loss.
Okay. All right. Pull in here. Okay. You have a history, Joe. Well, you have a history of taking Adderall. Is that correct?
That's correct.
When did that start?
At the age of 18 years old.
Okay. And when you were in undergrad, were you still on the Adderall?
Yes.
You were on Adderall in law school?
Yes.
You were on the Adderall when you took the bar exam?
Yes.
Were you on the Adderall when you passed the character and fitness portion?
Yes.
Okay. And you began practicing law. And when you first began practicing law, you were also on Adderall at that point also, correct?
Correct.
Okay. And is that prescribed by a physician?
Yes.
Okay. And pardon?
Sorry, I sneezed.
Oh.
God bless you.
Thank you.
And as long as you stay on your Adderall and your prescribed medication, you have no issues whatsoever. Is that correct?
That's correct.
Okay. Now, when the counsel asked you about it in January during the sworn statement of having, do you have a mental illness? And you said no. Is that correct?
Mr. Sandfield, we've lost the video here. Can you pause until we get the video back, please?
Is that my video? Oh, the
Yes.
picture. I don't think there's anything I can do. Oh, great. I don't think there's anything I can do about this. Comes and goes on its own.
Well, when it goes, you'll have to stop.
Let me try turning it off and on.
Mr. Stanfield, try that one more time, turning it off and back on. There we go.
Okay. When Miss Fleming asked you about let me see how we can do this.
That's the question.
I'll just do it like this. When Miss Fleming asked you about did you have a mental health? I can't exact. What was the exact question? Did you have a mental health illness? You responded no, correct?
Correct.
Why did you respond no?
Because I do not have a mental health illness.
What kind of what are you taking Adderall for?
For a neurological enhancement.
Is it ADHD?
Yes,
Okay. And ADHD is not considered a mental illness, is it?
it is not considered a mental illness.
Okay. And when she asked if you were treating for a mental illness, you said no. Is that the same reason?
It is.
You said no because you weren't treating for mental illness, you were treating for ADHD.
That's correct.
And ADHD is what you've had since you were 18.
Yes, sir.
Okay. And are you compliant with your medication?
I am.
Do you have any problems maintaining your medication as prescribed?
No.
Are you having any problems with delusions or hallucinations or inappropriate thoughts or anything of the like?
No.
Do you feel have you been representing clients recently?
Yes.
Have you had any problem representing clients?
No.
Have you been to court lately?
Yes.
Okay. Was one of the reasons you failed to appear for Justin Donaldson was because he failed to communicate with you and he failed to pay his attorney fees?
Yes.
And I think, whether right or wrong or otherwise, didn't you say that, strike that. And when you filed these motions, that was essentially to get your client's case back on track, wasn't it? The motion to set aside the bench warrant.
Yes.
Because that failure to appear, the bench warrant was issued because the client failed to appear and you failed to appear, right?
Yes.
But then you filed the motion to attempt to get him back on track, and the client still failed to appear.
Right.
Okay.
And I appeared.
And you appeared.
Yes.
And is it true that Judge Franicogli in the 40th District Court set aside the bench warrant contempt proceedings and close that issue as to you?
That's correct. That's true.
Okay. And you recall telling the fire inspector, strike that, the fire, not the inspector, but whatever he was, the person responded at the fire 17 months ago. You recall telling him that you were building a fire to get rid of evil spirits?
No.
Okay. And the fire was completely contained within the fireplace, wasn't it?
It was. That's the truth. Yes, sir.
Okay. And when there came a point in time when the police officer, one of the police officers testified that you were taken into protective custody, transferred to McLaren Hospital. Do you recall that?
Yes.
And were you evaluated at McLaren Hospital by a psychiatrist? Was there a psychological, did they have a consult for a psychiatrist?
Yes.
And did the psychiatrist indicate to you there was no positive findings?
Correct.
And you were discharged from the hospital the next morning?
Yes.
The only thing they did was do some blood work, right?
Correct. Right.
And they didn't recommend any treatment.
Right.
And is it also true that the petition for mental health treatment filed by Zachary Chodakok, I think is his name, nothing happened with that, did they?
Nothing happened with that.
Were you ever advised by probate court that they were going to accept a petition for mental illness?
I was never, no.
Okay. And some of these allegations are 17 months old. Would you say that in the last 17 months you've progressed way better?
Neurologically?
Yes.
Yes.
You're doing better with your medication?
Yes. Spiritually, yes.
And did you change physicians recently?
Yes.
Was that in January of this year?
Yes.
And did that physician change your medication?
Yes, he did.
Okay. And did that change of that medication, is that helping?
It is.
Okay. You feeling better?
Yes.
Okay.
Yes.
So that's been going on for about, 8 months?
Yes.
And you're compliant with the medication?
I am.
You're taking exactly the dosage you're supposed to and when you're supposed to take it?
Yes, sir.
Okay. Let me see what else I hear. Were you aware that, okay, now with regard to this lightning, did you actually feel like you were struck by lightning? What happened on that date, if you can
There was
recall?
a sensation of there was a torrential down. There was a downpour of rain, and there was a storm.
Were you talking on your cell phone?
I was on the cell phone at that time.
And do you feel lightning hit the cell phone? Or you don't know?
I don't know.
Okay.
I can't recall.
But you did feel a sensation that led you to believe you had a lightning issue.
Yes.
And you went to Henry Ford?
Yes.
Okay. That's on 19 in Garfield.
Yes.
Is that right? Yeah, 19 in Garfield. Okay. And when you said you went there and you had a continuum of care, you testified that You were supposed to have no heavy lifting?
Right.
Was there anything else in the report that you were supposed to do or you don't recall?
That's all the doctor advised.
Okay. And with regard to these B&Es, did you make some reports regarding somebody breaking into your office?
I did.
And did you have a basis for those reports?
Yes.
What was the basis?
The pry marks on the west and the south doors.
Okay. Isn't it true that the detective who wasn't called, or the evidence technician who wasn't called, her name was Swenson, badge number 348. Isn't it true that she found evidence of a B&E? Okay.
Yes.
Okay. Are you happy with the current position you're going to?
I am.
And do you think that individual is addressing your ADH issues and providing the appropriate medication to address the same?
Yes.
And based upon that, are you feeling that you are capable of continuing the practice of law?
Yes. Developing and expanding my practice areas.
Right. Have you had any contact with law enforcement since those discussions were had on the record today?
Nothing more than minor traffic violation.
Other than that, no.
Nothing more.
I'm sorry, I didn't hear what kind of violation.
Nothing more than a minor traffic violation.
Okay. You have anything else you want to tell the panel?
That's all. Thank you, Tri-County panel.
Nothing else.
Ms. Fleming, any further questions?
Mr. Campbell, during the investigation, did you ever provide documentation to confirm your hospitalizations?
To the Attorney Grievance Commission?
Correct.
No.
And you did not provide any information to indicate what the disposition was of the mental health petition, correct?
Yeah, no, it's been asked and answered both in direct and cross.
You may answer, Mr. Campbell.
Ms. Fleming, will you please repeat the question so I can answer it?
You just testified regarding the disposition of your mental health petition, correct?
Repeat the question one more time, please. Slow down.
You testified regarding your mental health petition, correct?
Testified today about the mental health petition?
Are you talking about in January during the sworn statement?
He just testified regarding the disposition of the mental health petition. Do you recall your testimony regarding the petition?
Are you talking
that it was
about
denied?
Right, okay.
That it was denied.
Have you ever submitted or provided documentation to confirm the outcome or evaluation as you just described today during testimony?
Submitted to who?
Could you please answer the question? Could you please answer the question? A direct question has been placed. It's not capable of being misunderstood. Would you please answer the question?
I have not submitted documentation to the Tri-County to the best of my knowledge.
I don't have any further questions.
I wanted to backtrack real quickly. I forgot, I overlooked something. Did you submit to a psychological evaluation with Dr. Wooten?
Yes.
And did you attend all the sessions he required of you?
Yes.
How many sessions was that, if you can recall?
4 sessions.
4 sessions?
Yeah.
You attended all of them?
Yes, sir.
And you paid your half of the evaluation fee, $26.50, has been paid, right?
Yes, sir.
And is it your understanding that evaluation should be available at the end of this month or beginning of next month?
Yes, sir. At the end of this month.
Okay. I have nothing else.
Does the panel have any questions for Mr. Campbell?
I do.
Go ahead, Mr. Thomas.
Did you tell Dr. Wooten that you had ADHD?
Yes.
Did you tell him that you had been prescribed medication?
Yes.
What was the medication?
Adderall. Adderall, Your Honor.
Is that the medication that you're taking now?
No, Your Honor.
You can call me Mr. Thomas. That's fine.
No, Mr. Thomas.
All right, what is the medication you're taking now?
Vyvanse.
And you say that that medication is working better?
Yes, Mr. Thomas.
And spell that for me, would you please?
Yes, Mr. Thomas. Vyvanse.
And how long have you been taking that?
Since January 2025.
And what is the name of your physician who prescribed it?
Dr. Garcia.
First name, Ernesto?
I can't recall. I don't know.
He's a nobody.
When's the last time you saw Dr. Garcia?
2 months ago.
And you've been on this Vyvanse for how many months?
8 months. 8 months this month.
When you went to Henry Ford, you were there for 1 day and released?
Yes, Mr. Thomas.
What tests do they give you?
A psychological consultation and
At Henry Ford? And what did the blood?
Wait,
What did the blood? I'm sorry.
Yeah, the witness said a psychological consultation, and then you both kind of broke up, so I didn't hear.
Okay, and he said, and a blood draw. Is that correct?
This is at Henry Ford Hospital in 19 in Garfield.
What did you just say?
In Clinton. Yes, sir. That's correct. True statement. Yes, sir. That's the truth.
You had indicated that ADHD is not a mental illness. Is that correct?
Yes, sir.
Are you aware of the DSM designation of ADHD?
No, sir.
Who told you it's not a mental illness, if anybody?
My attorney, Mr. Sanfield.
All right, I'll strike my own question.
By the way, we have
No further question on that regard. I have no further questions along any of the lines that I've gone. So thank you so much, Mr. Chairman.
Hey, Mr. Campbell, thank you. That'll conclude your examination. You can step down, and I'll return now to Ms. Fleming.
Thank you, Mr. Guerriero.
For your next, where are we?
I don't anticipate presenting any additional testimony.
You're resting?
I am.
Okay. Mr. Sanfield?
Yes, sir.
It's time for your case. Are you offering any witnesses or exhibits today?
I was going to ask that it be continued so that I can possibly bring in that evidence tech Swenson, who was not, whose information was deleted in accordance with the Brady versus Maryland. And also, I might look into some of that medical report from McLaren also, considering that's potential exculpatory also. And in my opinion, that should have been part of Ms. Fleming's report, but about her witness list. That was on her.
We're not doing that. Okay. If we already indicated to you that the issue of the evidence tech, I guess the name we've now identified as Swenson, the report which incorporates evidently some of her findings, has been admitted as evidence. We told you at the beginning of the hearing that if necessary, we would keep the record open for the limited and specific purpose of taking testimony from that witness should you deem it necessary to your case or helpful to your case, however you want to characterize it. And that's the limited relief we offered you on that motion.
No.
And if you have, my question to you is, leaving that aside, do you have any other case to present while we are here today?
May I have a brief moment to discuss this with my client?
Sure, 5 minutes.
All right. The panel, I believe, is ready to proceed. I'm going to close their breakout room here momentarily.
Oh, great. My picture's gone.
Yeah, I'm going to delay just so
Hold on, let me
maybe
see
we
what
can.
comes back. Delay until this comes back.
Yeah,
I got to do something with that security software. It's too sensitive.
agreed.
You agree the security software is making me mental. Oh, I don't want to say that in front of Caitlin.
So we're going to close the breakout room. We've got Mr. Guerrero here already. So
Can we do this? I can't believe this. I apologize. Never should have turned off the video.
everything is running perfectly fine here on my end, Mr. Guerrero. I'll hand it back to you.
Okay, we're back on the record. Mr. Sandfield, any witnesses or exhibits you wish to present on behalf of the respondent?
I don't have any. Sort of like my picture. I do. Hold on a minute. I do have a question now. Am I allowed to make a motion for directed verdict? Never back.
You can make whatever motion you want, but it's inappropriate. The record isn't closed yet, number one. Number two, it'd be a very unusual situation in the context of a disciplinary hearing.
All right.
I'm not going to zipper you up, but be aware that
if you're telling me it's
motion
not,
you want to make, we will deal with in our final adjudication of the matter.
If you're telling me it's aberrant, then I'm not going to do it.
Well, can I jump in? I can't see you, but you can hear me. The prosecution, has she rested?
Yes.
Yes.
Has she moved for any exhibits that were spoken of that were not admitted?
No.
No.
Okay. Then, prior to your presenting your case, Mr. Stanfield, you can make a motion. And I'll tell you that we're inclined to take that under advisement, but then do you intend on presenting any witnesses or evidence?
You talking about today?
Today.
He's already indicated he is not going to do that, Mr. Thomas. So
okay. So
he has rested his case subject to the one caveat that we've discussed and will memorialize shortly.
I'd also like the opportunity to, I maybe have to speak with Ms. Fleming on that, is depending on when the Wooten report is available, I'd like to discuss maybe, since my proofs still remain open, maybe bringing that into play also.
Well, one thing at a time. This is for the directed verdict. Okay.
Okay, my motion is for directed verdict in favor of no finding of mental incapacity at this time. My client's clearly testified. You can see he's very credible. He had no problem answering your questions. He did so. Damn it. He did so. I think it was very coherent. He testified to being on new medication since January, devoid of issues. The Attorney Grievance Commission has the burden of proving by preponderance of the evidence that my client is suffering from mental incapacity at this time. I think the panel could take judicial notice of the fact that he is not. There's been not a scintilla of evidence from a medical specialist or a medical individual indicating that my client is devoid of mental capacity or incapacity to practice law. Her testimony consists of a bunch of police officers who responded to B&E claim, and a firefighter responded to a fire 17 months ago. That stuff is barely relevant today. The testimony from Deborah O'Brien should be given little to no weight in view of the fact that she's on the opposite end of my case with Joe regarding parenting time and other issues pertaining to his child and his son. So she has a vested interest in trying to help your cause to my client's detriment, because it would circle back and help her client on her case, on the parenting time case, which is pending. So when you consider the totality of the circumstances, I think this is an ideal case for directed verdict in favor of my client, and dismiss the petition as to count one.
Thank you, Mr. Sandfield. Any response, Ms. Fleming?
Thank you. I just asked that the motion be denied. On behalf of the grievance administrator, a number of witnesses have testified today regarding concerning statements that Mr. Campbell asserted through over the course of a significant period of time. He's still seemingly dealing with some impacts of his mental health and his personal life. Additionally, exhibits 1 through 6 and 8 through 14 have been admitted, which also substantiate the allegations that were made in the petition to transfer to inactive status. So at this time, we would ask that the motion be denied.
Any questions from the panel with regard to the motion?
Yes. The standard that we are going to employ for the determination of whether or not a motion for directed verdict should be whether there's any evidence that a reasonable person that's making a decision would sustain the allegation, any evidence. And so do you agree with that, Mr. Sandfield?
I think that is the right standard.
All right. And then how about you for the Attorney Grievance Commission?
I believe that's accurate.
All right. So then with that understanding, Mr. Guerrero, I'll be happy to make a decision if you wish, consistent with what we've discussed before, or I'll wait for you.
I think for immediate purposes, we will take that motion under advisement, because I think it deals with the essential elements of this matter, and I think we would be well served by discussion amongst the panel in reference to the exhibits during that discussion. However, given the fact that both parties have now rested their cases, we will consider this hearing complete with the exception, and we will be keeping the record open for the limited purpose of the respondent and counsel being able to assess whether the witness and related exhibits, if any, concerning the evidence technician who attended the scene at Mr. Campbell's office needs to testify. And the counsel for respondent is directed that by next Monday, August 18th, he will notify the attorney discipline board through Mr. Montgomery whether he wishes to call that witness.
I would need more than a week, because I have to contact the police department. These people are not jump through hoops based on an attorney calling, as you're probably aware. I don't know what I have to do to talk to her. I mean, I don't know what the urgency is in a week. I'm thinking 30 days at least, so that.
No, Mr. Steve?
I'm sorry. Whatever.
No, go ahead. Finish it.
I just think that a week is too short, because I don't know what I'm going to encounter. That's my only problem. I don't know what I'm going to encounter. I call over there and talk to the police department and say, I need to talk to this witness, and is she available, and so forth and so on.
Mr. Sandfield, you've had constructive awareness of this situation now for already several days, 5 days by your count, more by Ms. Fleming's count. You're going to have this week to determine whether you want to call this witness. If you so decide you need to do it, you'll let Mr. Montgomery know, and we will reopen the record for that very limited purpose. If you decide you don't want to call this witness for whatever reason, or you don't need to, then the record will close, and this hearing will be considered complete. So you have until Monday, the 18th, to make that assessment, and I think the panel believes that's adequate time.
Is there a chance you're going to render an opinion before that date?
No, sir. We are giving you that time to make this assessment. You claim that there's exculpatory evidence. We're giving you the chance to make that determination and then determine whether you want to bring that to our attention.
Yeah, I understand that.
The limited basis on which this record will be kept open.
No, I understand.
And nothing will occur in this case until the 18th, when you notify the Attorney Discipline Board case manager of your decision.
Decision whether or not I need to keep the record open or not. Is that the decision?
No, decision whether you are going to call this witness or offer any evidence relating to that which you have described as allegedly exculpatory evidence. That's the limited basis on which the record will be open. I want to be very clear about that. There's no other basis on which this record will be open. You've had your chance today to present any other witnesses or testimony, and you have rested your case, subject to that caveat.
Well, I wouldn't say that I've rested. Well,
you have. You have. Subject to that limitation, you have rested your case.
Very well. I just think
Let's not quibble about that. At that point in time, once you've informed the Attorney Discipline Board of your intent, we will then determine next steps. If the parties wish to, we'll have to see if we have to reconvene. If not, we'll advise you of the next steps at that time.
The only thing I would ask is that I get a little additional time to try to get that organized. Today doesn't really count. It's already 3:30. So there's no way I'm going to be able to follow up on that police report today. So you're talking about giving me essentially 4 days, Tuesday, Wednesday, Thursday, and Friday, 4 days to try to determine whether I need this witness and can I get a hold of her and will she be available to testify. I don't really think that's a sufficient period of time because I don't know what I'm going to encounter. I'm not dealing with somebody I know. I don't know how long. I don't know how it's going to unfold. And I don't say that's prejudicing anybody.
Mr. Sandfield.
Go ahead, Mr. Cole.
I was just going to make the point. If you have any reason for needing additional time, you can present that when and if that presents. You can let us know. Otherwise.
But it will have to be presented with evidence of your diligence in trying to meet the time frame we've set.
Precisely.
Okay. All right. I'll submit that to Mr. Montgomery if I run into a roadblock.
Right. With some documentation of that roadblock, please. All right. Anything else from the parties?
Thank you, Mr. Guerrero.
We're good. Thank you. Thanks for your time and thanks for your time and consideration on this matter.
Anything else from the panel? All right.
No. Thank you, Mr. Thomas.
Madam Court Reporter Cindy, thank you so much for your patience today. I know how difficult it is to keep up with the chatterboxes here, but we do appreciate your efforts.
Thank you. I was going to apologize, but it gets a little frustrating when you're trying to listen to everybody. So I appreciate your indulgence. Thank you very much.
There's nothing that lawyers enjoy more than hearing themselves talk. So you've done a great job, and thank you. We can go back to our room, and thank you, counsel. We are.
Excuse me.
I'm sorry.
That's okay. May I inquire, did the
I'm sorry.
Did the panel wish to hear or receive any closing statement? Or I know that the record is still open. If we hear by the 18th, would the panel prefer to have written closing submitted? I guess I would just ask for some direction in that regard.
Well, the way I'm thinking about it is that if we have to reconvene to hear the one witness and the parties wish to make some closing statement at that time, we'll take them at that time. If it's determined we don't need to reconvene, then the parties are free to submit a written closing brief or statement, and we'll advise as to the time frame for that once we know where we're going here.
Fair enough. Thank you.
That's optional though, correct? I don't have to do that if I don't want to, right?
If you
You don't
want
have
an
to-
argument, you'll get an argument, but we're asking for you to consider agreeing. Once we make a determination as to what you're going to do with this Brady witness. Okay, so we'll all talk a week from today, and then things will fall in place depending on what your decision is. But we're not looking for long delays here, Gary.
All right. So, but just so I understand, because I don't have a problem with that if she wants to put something in writing if we don't go back on the record. Just that I'm indicating my present intent is not to do so because it would just be a duplication of what I said in my motion for directed verdict.
We can
That's your
decide
option,
that
Mr.
when time
Sanford.
comes.
Pardon me?
That's your prerogative, Gary. That's fine.
All right. Okay. Thanks, Brian.
Okay, thank you all. We're adjourned for the day. Owen, the panel will meet shortly before we check out here.
Sounds great.
Thank you
I'll
all
open the
very much.
Thank you.